This is docket 251992FH, People of the State of Michigan versus Michael Antron Johnson. Counsel, your appearance for the record.
Good morning, Your Honor. EPA Bart Buxton on behalf of the people of the state of Michigan, here with probation.
Agent Funny, Union County Probation, Michigan Department of Corrections.
Assistant Public Defender Jacob Riley appearing on behalf of Mr. Johnson, who is present to my right.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide to be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
Thank you. Put your hand down. Sir, you were placed on probation after pleading to stalking, the misdemeanor stalking, punishable by 1 year, and domestic violence, third offense, punishable by 5 years. I have a request for a bench warrant that the court signed on June 18th, 2026. Counsel, you and your client have reviewed that?
I have, yes, Your Honor, we have reviewed. Yes, Your
And
Honor.
sir, have you taken any medication yesterday or today?
No, Your
Are
Honor.
you supposed to be on medication you're not on?
No, Your Honor.
Any sign of fever, COVID, or other illness?
No, Your Honor.
And you had enough time to speak with your attorney?
Yes, Your Honor.
And sir, this probation violation asserts as follows. Count 1, on or about June 14th, 2026, defendant engaged in assaultive behavior toward Alyssa Mix. Count 2, on or about June 14th, 2026, defendant had contact with Alyssa Mix. Count 3, on or about 6/14/26, defendant engaged in assaultive, abusive, threatening, or intimidating behavior by physically assaulting Alyssa Mix. Before we proceed, were there 2 instances?
Your Honor, there was the new charges, and then the added count 4 is in regards to alleged jail calls that Mr. Johnson has made.
So let's get to count 4. What is that?
The added count 4 is the new issues, Your Honor.
Okay,
So counts 1 and 3 all resulted in the domestic violence third case that he currently has in district court.
okay, what about count 4? There's amendment, so what is that?
Yes, so count 4 is the alleged jail calls that Mr. Johnson.
I need do you have it written, so on or about when did he make these calls?
On or about June 15th and June 16th, the defendant had contact with Alyssa Mix.
Gotta slow down, ma'am, I don't have speed writing here.
Sorry.
On or about what, June
June 15th?
or June 16th,
Yes, Your Honor.
2026,
Correct, Your Honor.
defendant contacted
Alyssa Mix.
from the Ingham County Jail
Correct, Your Honor.
using his account.
Correct, Your Honor.
All right, do you understand all 4 counts?
Yes, Your Honor.
Now, my question is, before we get to new charges or anything else, count 1 says on or about 6/14, he engaged in assaultive behavior. Count 3 also says he engaged in assaultive behavior. So are these 2 different instances on the same day? Is one verbal, one physical? Otherwise, they look duplicative, so I need some more information.
So
Do we know?
for count 1, it was for the behavior. And the count 3 was for engaging in assaultive, abusing, threatening, or intimidating behavior by physically assaulting her.
So what's the behavior in count 1? Was it physical assault as well? Were there 2 instances of physical assault? Otherwise, it looks like we're piling on.
Okay, they're the same, so we can dismiss count 1.
Thank you. When in the future, make sure we're clear as to what you did, because otherwise what happens is, for your information, is it looks like we're piling on, and then in the Court of Appeals is going to say you didn't provide adequate notice. So if he hit her in the jaw in count 1 and then kicked her in the rear end in count 3, that's 2 different assaults. Okay, it could be deemed 2 different assaults. But otherwise, it looks not good for us, and it looks like we don't know, and we're just piling on, and we're in notice state, so I need you to be specific in the date, place, occurrence, okay?
Yes, Your Honor.
Okay. Are you waiting further arraignment, counsel?
Yes, Your Honor.
And on behalf of the people, there are new charges in regard to all of these things?
Correct, Your Honor. There has been a new charge of domestic violence, third offense, habitual second. There was a PCC in district court here in this county yesterday, and there is a preliminary examination set on July 2nd at 9 a.m.
And what about the contact? Was that charged, or is that something?
It has not been charged as of yet, Your Honor. Our office has not had a chance to review those calls in their entirety.
So we'll hold this all in abeyance?
So yes, we would need to hold this all in abeyance at this time, Your Honor.
All right, can we set this for then August? When do you think it'll be over? August or the end of June, or what?
With the exam being on July 2nd, if there was an exam or a waiver at that time, the case should be up here, Your Honor, at the beginning of August.
Okay. So let's set this for August 5th at 11. I don't know if we need to move that or not, so council will have to keep in contact and then know that you don't need my permission to move it, because we will need to see if it gets bound over, when it gets bound over, and if you need a transcript. So it may very well be later than that, all right?
Yes, Your Honor.
And so that would be for the PV, and I'm just gonna make a note, he was arraigned. Sir, your attorney can ask for bond, denied. We have a long history here. There were two victims, Dexter Jones and Alyssa Mix, that you were not to contact pursuant to probation. You ended up pleading to domestic violence, third offense, and aggravated stalking was dismissed, attempted interfering with electronic communications was dismissed, assault or assault and battery was dismissed, the habitual offender offense notice was dismissed, and assault with intent to do great bodily harm less than murder or by strangulation was dismissed. You got an absolutely unheard of plea agreement. So your attorney did a good job for you. Prosecutor gave you the benefit of the doubt. This court gave you the benefit of the doubt. Probation's been working with you. Now I have more allegations. No contact means no contact. Mr. Jones, Ms. Mix does not exist in your world. I've already gone through this with you. And here's how this works. I can revoke probation, I can send you to jail or prison. But meanwhile, if this continues between now and our upcoming hearing, it's contempt. And I want to explain to you what contempt means, because you and I need to be on the same page, and I need to inform you of this, because this is a notice state and you have an absolute right to be noticed of the consequences. So contempt carries with it 93 days and or $7,500. That's criminal contempt. You violate this court's order, this no contact order, and it's 93 days. I'm going to tell you here and now, I can and may give you 93 days for every phone call, because every phone call or contact through a third party or otherwise is a separate incident. That jail time does not count against the primary offense, because it's a separate offense. So if you'd like to wear that jumpsuit and put a hold on your life, go ahead and violate. You want to enter prison, go ahead and violate. I'm about public safety. I put you on probation instead of jail for rehabilitation, for reformation. So you learn a different way of life rather than stalking and being in contact with someone who does not want your contact, who is not safe with your contact. And so we have public safety. Now, if you can't be safe, then the prison awaits. All of this is within your control, not my control, not probation's control, not the prosecutor's control, not your attorney's control, your control. So you decide if you want to be a free man who's worthy of being rehabilitated or an imprisoned man who has law enforcement watching every single thing you do, and the most fashion-oriented statement you're gonna have is some Crocs in a jail jumpsuit. Maybe you'll be lucky to not always wear blue. Maybe you'll wear orange or yellow or red or some other Crayola color. If that's what you want, that's what you're gonna get. Have I been clear?
Yes, Your Honor.
Do you understand what no contact means?
Yes.
Tell me.
Can't have no contact with the victim, can't be within 1,000 feet of where they work, live, go to school. If I'm at the store or she's at the store, I gotta automatically leave. No ifs, ands, or buts about it. If she's my native, if I get a house and she end up moving right next door, I gotta find a new place to go.
Right, she shows up naked, you call 911. No messages through Hallmark cards, flowers, carrier pigeons, third parties, smoke signals. Don't get creative, because see what happens is you're in that jumpsuit. I don't play on this, sir. It is public safety. It is her safety. And she should not live in fear of you being around. I don't know what you're talking to her about. I don't know what the great need is, and I don't care. No contact means she doesn't exist on this planet. She's been erased from your life in every way, shape, and form. Do you understand?
Yes, Your Honor.
You will be in front of me immediately if there is another call from the jail. And if you think that you can use somebody else's name, use their phone privileges in the jail. These prosecutors know exactly who you are. And they will figure it out. Yesterday, I had someone who did that 1,141 times. He is now on his way to prison for 7.5 years. Do you want that to be you?
No, Your Honor.
Then quit it. Now, I say this, although you have a presumption of innocence on this, and it's by preponderance of the evidence, when we go to hearing on this probation violation, unless it's contempt, and then it could be beyond a reasonable doubt. We'll see which way we go. Bond conditions for the safety of the public and the safety of the victim. And that's why I've given you this. And I'm presuming that that happened because I am about public safety, and that's what bond considerations are. So at this time, bond is revoked, and I don't care what you got going on in your life. You can't keep Ms. Mix safe and stay away from her. That's the end of it. Anything else for the record on behalf of your client?
Nothing further at this point, Ron.
On behalf of probation?
No, Your Honor.
On behalf of the people?
The only other thing, Your Honor, and it's just so the court is made aware of it, this is not a new count that probation has added this time, but it is also my understanding that when the defendant was released previously after sentencing, he did not report to probation. So I don't think
Did
anything can be
did he
done.
ever report?
I don't
No, Your Honor.
Well, that ought to be a violation. And I'm adding it right now. Sir, I sentenced you, let me see,
June 3rd.
June 3rd. Did you make an appointment? You had 24 hours to make an appointment with probation.
So I went there I went to probation the next day, and I went there the next day, filled out the paperwork, and I gave them my sister's phone number. My sister,
Just a minute, did you fill out the paperwork to your knowledge?
No, Your Honor, I attempted to get a hold of Mr. Johnson several times via his sister as well. She told me she had no contact with him and had no idea where he was at.
she knew exactly where I was at. She knew I was at the mission. She could have came up there.
The mission down here?
Yes,
You walk over here, it's not that long of a walk, and you make the appointment.
Your Honor,
Yes.
sorry, I did go across the street to the mission and I handed them a card and I advised him to report to me immediately or come in that following Monday because it was a Friday. And he was arrested on that Sunday.
So I'm adding account 5, failed to make and keep an appointment with probation within 24 hours. These are all violations that should be told to the court before I proceed, or as I'm reading this. That is definitely an allegation that I want to talk about. Even if I don't do anything about it, I certainly can have a chat with them. Sir, she did everything but call law enforcement to do a ride along to find you. Your obligation. So let me just tell you, you have a 5-year felony. And if I find that you are not good for probation, let me just look at your guidelines for a moment. But given all of this and the continued contact, I don't even have to follow that. I can make a record that you simply can't be safe. Your guidelines are 14 to 29. And you have a 5-year felony, which is 60 months. So I can do 40 to 60. How's that feel?
not good.
Well, then I need to see some improvement, because otherwise that's very well what I may do to keep everybody safe and to teach you a lesson, get you rehabilitated once and for all behind bars in prison. Anything else?
No, Your Honor.
No, Your Honor.
Thank you. This should be set along with his new charge if it comes up. And I guess what I'm gonna do on the 5th, let's do a PV pre-trial, because we may not be able to deal with the PV until there is a resolution, if there will be a plea, and then we can globally resolve it. So if there's a pre-trial and we still can't deal with the PV, then it doesn't need to be on my docket for hearing. You can just deal with it as a pre-trial. We could do that. We could take a break at 11, or you can move it to 1 o'clock if you prefer. Would you like me to move it to 1 o'clock? Because I know you do pre-trials then. It's up to you.
Either way is fine, Your Honor. If we do 1 o'clock, I have no issue with that.
All right, let's do 1 o'clock instead of 11, and that's really, because it was a pre-trial, then we'll just move it along to the final pre-trial stages and all of that. Is that all right with you, counsel?
Yes, Your Honor.
Perfect. Any questions about what I mean, sir?
No, Your Honor. I got one.
What?
So, when I got out on the 3rd, I get out, I go straight to the mission. The minute I get there, I settle in, and I leave out. Her friend,
Sir, if her friend, you can talk to her friend, but not about her.
no, it's not the point I'm trying to get with.
You don't want to talk about the underlying issues because your rights are going to be impacted. So if this has anything to do with these alleged 4 counts, 2, 3, 4, or 5, you are squashing your rights, literally.
Never mind.
That's all for this record.
Thank you, Your Honor.
Your Honor, may I approach real quick? What is the date of funding? And I didn't know until I wasn't aware. So just like so. Very good. So I just wanted to. Everybody is here and yeah. Okay.
We're gonna do Keyshawn Thompson next. Each one, catch one. Oh,
All right. This is docket 26957 FH. Is it Kajan? How do you say your name, sir?
Kiwan.
Kajan?
Kiwan.
Kajan Thompson. Counsel, your appearances for the record.
good morning, Your Honor. AP Burt Bucks on behalf of the people of the state of Michigan.
Karen Robinson, Assistant Public Defender for Mr. Thompson.
And sir, are you in agreement with not being next to your attorney for this
Yes.
hearing?
Yes.
Taking any medication yesterday or today?
No.
Are you supposed to be on medication you're not on?
No.
Any sign of fever, COVID, or other illness?
No.
Why are you on Zoom and not in this court?
Because I got the paper said that I can appear by Zoom, and I had some damage to my vehicle. It was
All
I
right. I don't know what
it wouldn't
papers you
start.
got.
It wouldn't start, so I had to get a new starter, Your Honor.
All right. Well, I appreciate that. If you were here, you'd be arrested.
Why?
Why? Because I can't go to sentencing. You were specifically told to report to probation for a pre-sentence investigation report because I can't get to sentencing. And this is not the worst crime in the world, and we should be able to handle it today. And yet you're wasting time on my docket. I have to set this out a couple of months because you did not show up for a pre-sentence investigation report. So here's what we're going to do.
Your Honor, Mr. Kukowski emailed me the packet for the PSI. I have it next to me, and I filled it out, and I emailed it back to him.
When did you do that, sir?
He emailed it to me last Monday, and I emailed it back to him, I think either last night, and I tried to email it to him this past Monday. So I double emailed him, but I emailed it to him again to make sure that he got it.
When did you contact him?
He contacted me last Monday by email and by telephone.
That is not the question, sir. When did you contact him? I ordered you to go down to probation.
When I initially, it was, I think the next day after you told me, I had called and the court said that they didn't have my case because it was too new and that I had to call back the following week. So then a week went by. I called and they still didn't have it. But then I got an email from him saying that he couldn't get a hold of me because he tried to call me. He said the phone number was incorrect. And I was like, what number do you have? And the number he told me was 857, and it's actually 859. So then he was like, okay, I need you to come in. I was like, Mr. Kukowski, I've really been missing a lot of work because of this, and I'm getting behind on my bills. Is there any way that you can email it to me and I can, fill it out and send it back? He was like, I really don't know if I can do that. I was like, I'll call the court and ask for permission. Then he called me
All right,
a
sir,
week
I don't
later.
wanna hear it, I don't wanna hear anymore. I have a huge report from him, about, he sent you this, pre-sentence investigation packet on the 15th. He attempted to contact you then at the correct number on 6/17, and you just gave it to him last night, which he can't possibly do. This is like a 12-page report. So now we can't get to sentencing. So here's the deal, you prioritize this, or what about that, sir?
This is the paper that I got from you guys, my plea of rights, and this is the phone number that I provided on the bottom. And this is the number that he said he
Okay,
couldn't
I
read.
got that, sir. Sir, I'm not fighting with you because he then gets the correct phone number. On 6/17, he attempts to contact you and was unable to connect with you. So he must have left a message, and it's up to you to immediately provide that because he can't do it overnight. And if you don't prioritize me, I don't prioritize you. What I do is I put you in the slammer and have you serve your time then, and then you'll miss work. So here's what I'm gonna do, and I don't have to do this, so do not mess up again. I will take no excuses. So here's what we're going to do. This new sentencing is going to be September 17th at 10 a.m.
But Your Honor, can I ask, did he get the PSI that I sent him?
I have no idea. I don't care. Your job to figure it out. You call him every hour on the hour today till you reach him. He's a very thorough, follow through kind of guy. So you leave him a message and say, can you verify, can you verify, can you verify? And if not, you can't reach him, you've got an attorney. Because
I have no problem.
I can't proceed without this. So you got this one last chance. Otherwise, you sit in jail until it gets done, and I can tell you, you didn't prioritize probation, so they won't prioritize you.
I did.
So,
it's right here. Every paper filled out to the T.
You know what? I don't know if it got there. I'm not arguing with you. You want to keep arguing? I'm gonna hold you in contempt. I'm not wasting time on my docket today when you did not follow through timely. You may have done it yesterday. You may have done it the day before. That is not enough time for probation to get it done, which is why we give them 6 to 8 weeks. So you got a new sentencing date of September 17th at 10. I don't want any excuses. Your car's not working. You Uber it, you ask for a ride, you walk it. I don't care. Do you understand, sir?
Yes, Your Honor.
Now, does that time and date work for everybody?
It works for me, Your Honor.
Great. Keep in contact with your client and probation, and let's get this done. We've wasted your time as well, counsel. Sorry, that's all for the record.
Thank you, Your Honor. Next case is Arthur Stovall, Your Honor.
Says there's 17.
This is docket 253390FH, People of the State of Michigan versus Arthur Lee Stovall Jr. Counsel, your appearance for the record.
Good morning, Your Honor. APA Bart Buxton on behalf of the people of the state of Michigan.
Good morning, Your Honor. Vita Rothstein from the Ingham County Public Defender's Office, appearing on behalf of Mr. Stovall, who is present in the courtroom and standing to my right.
Thank you. Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
Thank you. Put your hand down. Have you had enough time to speak with your attorney?
Yeah,
Have you read the pre-sentence investigation report?
yes.
Have you taken any medication, marijuana, alcohol, anything at all yesterday or today?
No, Your Honor.
Are you supposed to be on medication you're not on?
No, Your Honor.
Any sign of fever, COVID, or other illness?
No, Your Honor.
And you're remaining happy with your counsel?
Yes, Your Honor.
Thank you. You pled guilty to operating while intoxicated, impaired, controlled substance. Third, punishable by 5 years. Do you recall that?
Yes, Your Honor.
All right, thank you. And on behalf of the people, any corrections, additions, deletions?
I do have one brief correction to the body, Your Honor. The attorney at the plea was Brian Jackson. However, the attorney at sentencing is Miss Rothstein. I believe it'd be appropriate to make that distinction in the report.
Any issues, sir, with having two different attorneys, one for plea, one for sentencing?
No, Your Honor.
All right, so I'm going to make that noted throughout the report. Any objection, counsel?
No, Your Honor.
That's on the cover page. It's also going to be on the basic information sheet. And we'll do an evaluation and plan.
It is in the evaluation plan as well, Your Honor.
Yeah, second paragraph. Correction has been made. Any other corrections
None for the defense.
as to the guidelines?
No, Your Honor.
No, Your Honor.
On behalf of the people, was there an accident here?
One moment, Your Honor. There was not, Your Honor.
All right, and I don't know if the prosecutor's office or law enforcement is asking or emergency services for.
So yes, number 31 in the recommendation by probation on the cover page does state $125 for the reimbursement for cost of prosecution.
Well, that, it says reimbursement.
It does,
So
that
we
is
have
for
to
cost of prosecution.
be clear on what it is. So that's for prosecution. What about the arresting agency?
Yes, Your Honor, the Ingham County Sheriff's Office also provided our office with a report that states that there was $460.38 for cost recovery.
And so no emergency services.
Not as far as I'm aware, Your Honor.
All right, counsel, are you aware of those?
Yes, Your Honor.
Thank you. Any other issues, or if not, you may proceed, counsel.
I don't believe there are any other issues, Your Honor, in regards to payments. I will say, Your Honor, I would ask that you follow the recommendation by probation. I do believe that 24 months is appropriate, given Mr. Stovall's extensive history, not only with alcohol, but with domestic violence as well. He does have a pretty lengthy history. Back from 1998, he's got an operating while intoxicated. I see a couple of public intoxications, Your Honor, some controlled substance issues. It's very clear that the defendant, who was even on probation for a OWI in DeWitt Township at the 29th Circuit Court. It's very clear that he has a lot of problems with alcohol, so I do believe the 24 months are appropriate, as well as the potential jail sentence. Thank you, Your Honor.
Thank you. Counsel, what would you like me to know?
Thank you, Your Honor. I agree with Mr. Buxton about the fact that Mr. Stovall clearly has a serious substance abuse issue. It does date back, it appears, to the 1990s, which was some time ago, longer ago than I care to admit, to be honest. I like to think of the 90s as not as far away as they are. But that being said, he is currently on probation in Clinton County and through December.
And what is that for?
that is for another alcohol-related offense. He would respectfully request that any jail time be suspended if the court is considering that upon successful completion of probation, because he does work and he is concerned about losing his income. I understand in the report that he did say that he doesn't feel he needs treatment at this time. However, I feel he needs at least intensive outpatient treatment at this time. That would be my personal opinion. Someone with a long history of substance abuse, as Mr. Stovall has, needs treatment of some sort, because right now I believe his addiction has been controlling him instead of the other way around.
I would agree with that. In fact, I think he probably needs residential, but I get to that.
There is no magic bullet cure, as the court's well aware. All we have is treatment. And so I know it's imperfect, but it's something that I think it's a disease and it requires treatment and at least intensive outpatient treatment for Mr. Stovall, because he's not going to get where he needs to be without it.
Is he on a spray tether right now?
No.
Not at the moment, no. He has been and
Yeah.
been successful on it. She's even successfully completed treatment before at Odyssey House. It's my understanding that's the case. It just, it's something that unfortunately this disease is tricky. It sneaks up on people. You gotta constantly be on it or it's on you. And that's just where we are. I would love to see Mr. Stovall move from sobriety to recovery and long-term recovery and be able to say he's gone decades without a drink. Hopefully that happens, but I think right now we're not quite there yet.
All right, thank you. So are you living in Eaton County? They're monitoring you, right? You said Eaton?
Clinton.
Oh,
Clinton
Clinton. Are
County.
you living in Clinton County?
No, I'm in Eden County, Eden County.
You're in Ingham.
Yeah.
Okay, is Ingham supervising you?
Yes.
Okay, very good. Thank you. And sir, what would you like me to know? I mean, you had a .201, it's 2.5 times the legal limit. You're a functioning alcoholic.
Your Honor, though at that time, I was making some really bad decisions in my life. I have now making right decisions, on the right path, doing the right thing, going to probation, treatment as well. I have a financial job. I'm very liked and well at my job and dedicated. So don't want to go to jail, but anything other than that, I'm providing for my wife. I'm newly married as well. So
Does your wife drink?
no, she doesn't.
Do you have any alcohol in the home?
No, I don't.
Marijuana?
No, I don't.
Okay.
I'm just trying to straighten up my act, Your Honor, and be rehabilitated and trying to do the right thing.
Where you're working at Pancheros, anywhere else?
Yes,
That's the only job you have?
yes.
Okay, so what days do you work?
I work 6 days a week.
When?
I only get 1 day off. It's Wednesday.
Well, here's the problem with that, sir. You're gonna have to get 5 days. You're gonna have to work 5 days. Unless you want me to simply put you in jail 30 days, credit for 9, and then you'll be out in, I don't know, a week and a half or so. Because the statute is very, very clear. I don't have an option here. If you get probation, it's 30 days to 1 year in jail, at least 48 hours consecutively. So I usually have you do weekends or whatever your days off are until those days are made up. So there is no option for me. So you're gonna have to work it out with your employer. Hopefully you don't lose your job, and there's, work wanted, help wanted signs in every window. I suspect you've been there long enough where they wanna keep you, so having 2 days off, shouldn't be a problem for them. If it is, there's other employers who would love to have you.
Yes, Your Honor.
So do you have a set day off or what?
Yes, Your
What
Honor.
is it?
Wednesday, but I can, they're more than willing to work with me.
Great, so do you want, Tuesday and Wednesday off, or Wednesday, Thursday off? I don't know, I don't know what their busy time is.
Truck day, let's take a Tuesday, truck day is a Thursday,
Okay,
so
and when do you get off on Monday?
I get off 3:30.
And when do you start?
I start at 8:30 in the morning.
Okay. Okay. And how far is the Pancheros that you work at from Mason, Ingham County Jail?
It took 14 miles.
Okay. Okay. So tell me about the treatment you've been going through.
With probation, I just started counseling with,
Where?
with CMH.
Okay.
I was privileged, I was seeing, it was one other, I can't think of his name.
That's okay. And so are you counseling for the substance abuse or other
Yes.
things? Okay.
Yes.
And are you going to AA, NA, or CA?
Not at the moment.
Why not?
I haven't been instructed. I've been past that, so I'm a little graduated through probation, so like my steps,
Sir, you have a lifetime of AA, NA, or CA. You need that support so you don't slide back. At some point, you're gonna kill someone. Okay, I just had a person in front of me who was incarcerated for several years because he killed someone while drunk. So your wife's gonna leave you for another man in those 7 or 8 or 10 years.
I hope that.
Well, that's on you, sir. Think she's gonna wait around for a decade?
No, Your Honor.
I don't think so either. So you got a lot to lose, sir.
Sure do.
And you know, how do you feel about somebody driving around with a 0.20, and yesterday I had someone with like a 0.32? 4 times the legal limit.
I feel really bad. Should not be drinking under the influence or be driving.
So those people, including you, you're driving around with all of us, we all drive the same roads. They're also driving the roads that your wife's driving. What if she falls prey to somebody like you?
I feel real bad.
Well, it's probably grief for years, right?
You're right, Your Honor.
Anger. Senseless loss happens every day in our community. Watch the accident reports, see how many people die or are injured for life because of alcohol. Alcohol is not needed in your body. I would be curious what your liver looks like. You want a long life with your wife?
I do.
Then stop drinking and let your liver heal. Your body's really smart, it can heal. But if you have cirrhosis of the liver already, you're not even gonna be good on the transplant list because you're not a high priority because you caused it through alcoholism. So it depends on if you want a life with your wife or if you want her to spend the rest of her life visiting you and putting a flower here and there and a flag here and there on your tombstone. There's only 2 roads here: sobriety, alcoholism, and death. Sir, you'll be on probation for 24 months. You shall not violate the laws of this state or any other. You'll not leave the state without permission of this court. You shall not use, possess, consume, purchase, or be in the presence of alcohol, illegal drugs, or drug paraphernalia, nor any guns, ammunition, imitation of a weapon. You'll not use any object as a weapon. If you have a need for any alcohol, medications, marijuana, you'll present a prescription within 24 hours to a licensed medical physician and only use it as prescribed. You will be tested, how often are you tested right now?
Once a week.
If you are positive, you will immediately go to residential treatment. Immediately. And then you'll be violated, but immediately you will go to treatment. Residential. Don't care about your job, your wife, or anything else, but you will have shown me that you are a danger. And I don't have to order that, you certainly can object. But then you can come in front of me for a violation, and the consequence may very well be jail or prison, and I think the consequence needs to be an immediate sanction, and that sanction is a rehabilitation sanction, which is not really a sanction, it's for your life, which will be immediate entry into residential treatment, long-term, following all aftercare. You understand, sir?
Yes, I do, Your Honor.
I suspect that is more palatable to you than going to jail or prison.
Yes, sure.
And I do that, and I want to make a record of this, is because I know addicts, and I was a sobriety court judge in district court for 4 years before I came up here, and had a long practice before I ever became a judge, and I know addicts, doesn't matter, drugs, alcohol, whatever your addiction is, pills, they go up, they go down, they go up, they go down. So this backward, forward, how we respond to it is additional treatment. If you don't take to the treatment, then it's prison. And I keep you and everybody else safe, but I don't wanna have to do that, sir. Get real. Have a serious conversation with your therapist and yourself and your wife. Ask for help as a sign of strength and healing. Work the program. You will be required to attend AA, NA, or CA no less than 2 times per week, and you will have a sponsor within 180 days who has become clean and sober through working a program and has been clean and sober for 5 years. That gives you some time to find somebody you like. There are AA programs all through the county. If you can't drive to one, you can do it online, although the in-person are the best. And you will find people just like you who will provide help, sometimes even give you extra work, rides, whatever it is you need. There's a whole community out there. You are not alone in this. They are there to support you and to help you stay honest and to call you on your crap, and you can call them on their crap. And that is the only way that people seem to recover for the long term, is to have this support for the rest of their lives. Maybe you can make it a date night because your wife should be included so she understands this issue and can help you along the way. I don't have jurisdiction over her, but a lot of spouses and family members attend. It's meant to be your success and your place to lean into if there's an issue, so use it wisely. I have to say the best ones generally seem to be the ones around churches, because there are some areas where they're in not the best neighborhoods, and so people who want to tempt you with alcohol and drugs stand outside till you're done with the meeting and then tempt you. So be mindful that there are better meetings than others, and if you're not happy with one, go to another. I had a law professor who was probably about 70 years old, and he used to call it the old fogies group, and he probably is still going, and this was a decade ago, but he absolutely found his people, loved it. They were all people his own age. There are some that are geared toward college students, so find the one that fits and attend it. I think once you attend, you'll learn to like it and meet some new friends that you can rely on and they can rely on you. You will meet with probation as often as required, no less than 1 time per month. You'll sign all necessary releases so we can verify that you're doing what you need to do. You will continue to work with community mental health counseling and follow all recommendations, including any aftercare. If you are positive for any test, then there'll be a secondary test to make sure it's not a false positive. If it's a positive for alcohol or any other substance, certainly counsel, you can ask for a hearing, but I will be remanding him to residential treatment. And you ought to just go and start and not waste the time it's gonna take to get in front of me. You will not engage in any assault or abusive, threatening, or intimidating behavior. You'll obey all court orders, recommendations from all physicians, treatment providers, and probation. Those become orders of this court. You'll notify probation within 24 hours of any change of address or employment status or cell phone number. You will not have written, verbal, electronic, or physical contact with anyone housed in the Michigan Department of Corrections or who's on probation or parole. If you have that contact, you don't have to ask anybody or everybody if they have that kind of background, but if you learn it, just let probation know. If everybody's in good standing, then we'll give you that permission. You'll contact probation today, make and keep your appointments, and they may very well tell you to just show up for your next appointment with the probation you have now, and that's perfectly fine with me. You'll allow probation into your residence at any time for probation supervision without a warrant and submit to a search of your vehicle, residence, cell phone, and computer. If there's reasonable cause to believe you have items that violate the conditions of your probation. Now, at your place of employment, do they serve alcohol?
No, Your Honor.
Okay, if you switch employment to a restaurant that does serve alcohol, that's okay, as long as you are not participating in drinking alcohol, you're not there after hours. Okay, so that's not their primary business. You can't work at a bar, but some restaurants do serve alcohol, or if they decide to get a liquor license, that's okay, as long as you're not on the premises after hours. Does that make sense?
Yes, sure.
You'll report any arrest, police contact, personal protection order, loss of employment, or change of residence within 24 hours to probation. Weekends and holidays are accepted. So if something happens on a Friday, tell us on Monday, Monday's a holiday, tell us on Tuesday. You will not drive a motor vehicle in accordance with the Secretary of State. That's their whole thing, and I only get involved under certain conditions, so I'm sure they've already provided you notice. You will maintain your employment, not give your employer any cause to terminate you. If you are ever unemployed, then you will be part of a work seek program. If you want to change jobs, you need permission from probation. You'll work a minimum of 30 hours per week. You can work more, but not less. You will serve 365 days jail with credit for the 9 days served. As to the 30 days that you must serve up front, you will report to the Ingham County Jail by 5:30, which is actually 2 hours after you get out of work, just in case you have to work late. Right, you get out of work at 3:30?
Yeah.
So 5:30, by 5:30, you'll be in the jail, and 48 hours later, you will be released. So that would, you'll report on Monday, that gives you Monday night, Tuesday night, so you'll be released Wednesday. Otherwise, I gotta do Tuesday night, Wednesday night, and then they won't release you till too late in the day, probably Thursday, so.
So Monday night,
Monday night and Tuesday night, then you'll be released Wednesday at around 5:30. So if you show up at 5, it would be 48 hours, so 5 o'clock on Wednesday. Does that make sense?
yeah,
So then you get a couple hours to relax before you go back to work. Shower, do whatever it is you need to do, have dinner with your wife, okay?
yeah, sure.
And you'll do that until you reach the 30 days. You get credit for the 9 days. So technically, it is 365 days with 30 days up front, but to be served on those days, so you don't lose your job. Okay, and then when that's over, you're good. The balance of the jail is held. And you get credit for those 9 days. So you'll be done fairly quickly. You'll pay a crime victims assessment amount of $130 and waiving probation oversight fees, and you will pay $125 reimbursement to the prosecutor's office and cost recovery in the amount of $460.38 to the Ingham County Sheriff's Office. All of that money will be paid through the clerk's office downstairs, so we keep track of it, and you'll pay a $68 state cost. Arrange a payment plan, so you can pay all of that by the end of probation. You'll not use any objects as a weapon. I've already talked about that, no marijuana. And I'm not, because you've already done the scram tethering and done well, I'm not going to at this time order the scram tether, but if for some reason they think you're using or you need it, we'll do it at that time. And they say 2 times per week for the first 6 months of probation testing. It's whatever rate they deem necessary and your treatment providers agree with. So probation, they have some training, but I rely on the treatment provider. So if the treatment providers say 1 time, if they say 3 times, if they say daily, that's what you'll do. And sir, if you decide to not go to AA, NA or CA, the 2 times that I've ordered, we're gonna do 90 and 90. And if we need to, we'll do 90 and 90 in jail. We have 42 days to appeal and to request appellate counsel. Counsel, is there anything I missed?
No, Your Honor.
And the vehicle, was that immobilized or
It's gone.
gone? Okay, sold or?
Yeah, I don't have it. I don't drive.
I understand, but in accordance with the statute, I just need to make sure that it's immobilized if you have it, or it was sold. So, okay, so you have that documentation?
My cousin, it was my cousin's car. It wasn't my car.
So you didn't have permission to drive drugs, so that's fine. Okay. Do you acknowledge receiving your appellate rights?
Yes.
All right, thank you. That is all for the record. Please go downstairs and see what your next appointment is. You can marry this file up with that file. You don't have to appear twice for probation. It can just be once, so.
If I already have a probation.
Just make sure they know that this file is also going to be included. So counsel, take them downstairs and just let them know that this is going to marry up with that. Is that okay? Yes. Thank you, that's all.
This is Jonathan Carthel, Your Honor.
All right, this is docket 256681 FH People State Michigan versus Jonathan Carthel. Counsel, your appearance for the record, and where is your client? Oh, there he is. Okay.
And good morning, Your Honor. APA Bart Buxton on behalf of the people of the state of Michigan.
Your Honor, Assistant Public Defender Sarah Donnelly on behalf of Jonathan Carthel.
And Assistant Public Defender Jacob Riley on behalf of Mr. Carthel.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
I do.
Have you taken any medication yesterday or today?
Your Honor.
Is there medication you're supposed to be on that you're not on?
No, I take I don't take medication. Only thing I take is Suboxone.
That's
I don't know
okay.
if that's a medication.
Yeah, it is. So, but that does not affect your ability to understand the court or your attorney. Is that correct?
Yes, it doesn't, Your Honor.
All right. And have you had an opportunity to review the pre-sentence investigation report and talk with your attorneys?
Yes, I have.
And you're all right with being in the Department of Corrections, correct?
Yes, Your Honor. Yes.
So you're all right with not being here in front of me and having your attorneys there, and if you need to speak with them, I will put you in a confidential breakout room. You're good with that?
Yes, Your Honor.
And you're feeling okay today? No sign of flu or anything else?
Yeah, I'm feeling okay, Your Honor.
All right, very good. Sir, you pled guilty to domestic violence, second offense, a 1-year misdemeanor. I'm sorry, you didn't plead guilty. You pled no contest. Sorry about that. You pled no contest to domestic violence, second offense, a 1-year misdemeanor, and also possession of a controlled substance known as cocaine, less than 25 grams, punishable by 4 years. Sure call that?
Yes, Your Honor.
Any corrections, additions, deletions on behalf of the people?
Yes, Your Honor. Mr. Carthel is currently being represented by both Sarah Donnelly as well as Jacob Riley. So I do believe that that should be reflected in the PSI.
All right, I'm adding, Mr. Raleigh, and that's on the cover. That is also on basic information sheet and probably under evaluation and plan. Any other corrections?
Don't believe so, Your Honor. Give me one moment. No, Your Honor, no other corrections to the body.
So I don't know if Judge Kennedy was here May 5th, but this says, attached here to and made part of this is a pre-sentence report completed by probation for Clinton Kennedy. Should that be me, or was Kennedy here and I inherited this?
Your Honor, so, Judge Kennedy was on the case that has Mr. Carthel currently in MDOC. He was in the Swift, I believe he was in the Swift Insure probation program at the time. So number 17 of 18, he was sent to MDOC. This case was in front of Judge Kennedy at one point in time, I believe. Actually, no. Looks like it never actually was, Your Honor.
No, it wasn't.
I think that's just from the, I believe that's just from the prior case, Your Honor, so I think that should be changed.
So I'm just gonna change it to me. It doesn't look like.
Yeah, it looks as if what it's referencing is the previous pre-sentence investigation report for the previous crime, and that this is just an update from that report.
Okay. So I'm just adding, following report is an updated report from a case before Clinton Kennedy III, and then putting my name because this is really prepared for me, not him. So they got it, it's just worded awkwardly. Okay, thank you. Because if they went and looked for a transcript, they wouldn't be able to find it the way this is written. So, okay. Any other corrections?
No, Your Honor.
Thank you, Your Honor. So from the defense, on page 2 of the basic information report underneath controlled substance, the offense 202, it says here it lists a victim as Robin Hoiskins. That is the victim on count 1, but there isn't, we would ask that be removed for count 2.
I'm sorry, where are you?
Just,
information.
Just page 2 of the basic information report where it lists the current offenses, count offense 1 of 1 and count offense 2 of 2. It lists a victim.
Oh, I see it. So that there's none?
Because it's a victimless crime, yes, we would ask that it be removed.
So, yeah, that should not.
The only other thing I could see here, yeah, the under the plea agreement on page 1 of the current convictions in the plea agreement, there was an agreement that he would plead no contest to those counts, and there was a dismissal of the HAPs, the habitual no offense notice, and we think that should probably be listed somewhere in there.
People have no objection.
Okay, and so after it says 25 grams of green comment and habitual, what was it? Fourth. We dismiss in its entirety, okay.
And then the only other thing is wherever it says sentencing date, Your Honor, it says that May 20th, it needs to be corrected to today's date.
All right, 26th June. On the cover page, well, then do we need jail credit days or no?
No, they are accurate, Your Honor, because he is MDOC.
And Your Honor, the sentencing date is on paragraph 3 of the evaluation.
Thank you. Okay, I think it's paragraph 2 for the sentencing date, and then he says he's under sentence as of September 4th, 2025, so he's not entitled to jail credit, so I think I fixed it. All right. Any other corrections?
Not to the body of the report, thank you.
And what about guidelines?
No change to the guidelines, Your Honor, thank you.
No changes from us either.
Okay, oh, I do need to go to instant offense and change the date, and that is 18/18. Right, on behalf of the people,
Yes, Your Honor, I would just ask that you follow the recommendation of probation. Thank you.
is there a victim who wishes to address the court?
Don't believe so, Your Honor, give me one moment.
I don't see anybody with her name.
Is Robin Huskins here?
Robin Huskins? All right. And you just want me to follow the recommendation?
Yes, Your
All
Honor.
right, counsel?
Yes, Your Honor, more or less, we would be asking the same, we just, want the court to know that, this report was done back a couple of months ago. The hope was that Mr. Carthel could do a concurrent term of, with his current MDOC, sentence. He, essentially, this happened, before he was incarcerated. So we were trying to make it so that he wasn't gonna have a delayed eligibility. He is eligible for parole on, April
3rd, I believe.
April 3rd of 2027. So he will be going in front of the parole board here soon. We just ask that the court consider, a sentence so that it doesn't delay his release.
Okay, thank you. Sir, what would you like me to know?
Your Honor, it's a lot of things I had done since then. You know, I had took VPI class. I done took substance abuse in here. I'm currently getting my GED. Listen, today I'm taking a plea, getting it all behind me because I'm actually grown. I'm getting too old to keep going through this mess. I'm actually trying to get my culinary art license, started at least for when I get out, I can continue it. And next time I see you, Judge, I would like you to be like, or getting something on my food truck. You know, that's the direction I'm going in.
You
So
invite
instead of me,
My kids love food trucks, so you just let me know where you're parked, okay? I'd love to see that.
yeah, and also I'm a motivated speaker, with the things I have done in my life with all the drug dealing and, drug using and all this crap. I can give it to the youth, I feel, instead of, and let.
Oh, geez. Hopefully they'll bring it back.
I've been on too long now.
I mean, we're only like, how long do they give you? Like a half hour or a whole hour?
We just have to jump and do these immediately, you have to run them into something. We just gotta take them out of order, because they're ridiculous.
And this was set for 10:30, so it's not even been 45 minutes.
For sure that he's trying his hardest to get back here.
Well. I think I have to sentence him face to face, but I could still sentence him. Because I'm gonna follow the recommendation, maybe we could get him a transcript, I don't know. You wanna wait, I don't wanna reschedule this, we can wait and see if he gets back on.
Thank you.
I don't know that you can even waive his appearance on this.
I would try if I could, I think.
I don't
Yeah,
think
because
you can.
obviously I think he wants this done, so.
Do we wanna call them and just say we need 5 more minutes? I mean, literally, we're at the bottom of this. It'll take me less than 5 minutes to say what I need. So let's try to reach a VOC.
I do have a phone number, Your Honor.
All right, why don't you give it to Brian to have a call, and then let's do something while we're waiting. We can move the morning along. Okay, what do we have next? While we wait.
It's gonna be Kendrick Campbell next, Your Honor.
Is she in custody?
Yes, he
Pardon
is.
me?
And I got another one if that doesn't work.
What are we doing?
Campbell?
Campbell.
We approach, we approach.
I have no problem with that.
Okay. We don't even, we don't even need to put that on the record, do we?
No, but I think the person needs to know.
What
Description.
what page is that? Oh,
Page 2, description of the text.
okay.
It's the third, full paragraph.
I'm just writing the first one back sentence. And so what was just make a record of is the first full sentence on paragraph 3 under description of narrative is struck. That would work. I think we're covered without exposing.
Thank you, as long as they know, but we'll get, I'll say that on the record, the first paragraph,
Yes,
the first
and I
sentence.
struck it, yeah, by stipulation.
Can we, which one?
Yeah.
So just.
Which reported they agreed about defendants infidelity. End of story.
Perfect.
Okay, moving on, this is docket 25-5440F8, People of the State of Michigan versus Kendrick Lamont Campbell. Counsel, your appearance for the record.
Good morning, Your Honor. APA Bart Buxton on behalf of the people of the state of Michigan.
Good morning, Brian Jackson, on behalf of Mr. Campbell, who is present in the courtroom for sentencing.
Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth and the penalty of perjury?
I do.
Thank you. Put your hand down. Sir, have you taken any medication yesterday or today?
My night medication.
Does that affect your ability to understand your attorney or this court?
No, you're not.
All right, we're gonna have a seat. We're gonna go, I need to take this other case with MDOC before, it's gonna be about 4 minutes, before they cut us off. Okay, we are back on the record on. Are you good, Nancy?
Yeah, I'll just, if we're done with this, then I'll finish what I have.
On docket 25-6681F8, People of the State of Michigan versus Jonathan Carfel. He is back from the MDOC on Zoom. Sir, can you unmute yourself? Did you get someone? They're coming. Okay.
Yeah, here it goes. Can you hear me?
Thank you. Yeah, so sir, then
Okay.
you were cut off saying that you wanted to be a motivational speaker, talk about your experiences with others. What else would you like to know?
Yeah, basically, I just want to get this behind me, Your Honor, and become a grown man, because I always been grown as an age, but I never been an adult. So I feel like I have no children. I feel like that one day I want to adopt. So I got to get my life in order to take this new kid and show him the right tracks or her the right tracks. It's just a lot of things I'm putting behind me, Your Honor, while I'm pleading right now and not fighting, not going all the way. I'm just pleading behind me, because you'll never see me again unless you eat off my food truck. And that's with that, Your Honor, I'm here to just take responsibility and whatever you feel fit.
I look forward to that food truck, and maybe I'll bring over some of my weapons court kids over, because some of them have culinary desires, and also they could use somebody like you to come talk. So maybe when you're released, you could come talk to my weapons court. They're young juveniles who get in trouble. They're in a specialty court to get a 90-day misdemeanor in lieu of a 5-year felony. And they would truly benefit from someone like you who's been there, seen it, and now your life's been on hold. And so, you could tell them what the next 20 years is gonna look like if they don't straighten up. So many of them are doing well, some are on the borderline. So we could certainly use you. So come on back, and I invite you to talk with them, and we'll get your speaking started. And let me know about that food truck. All right, so sir, I am sentencing you on count 1 to 24 days with credit for 24 days. And you will pay us $50 state costs. You will pay $130 crime victims, and on count 2, you'll also pay a $68 state cost, and you will be in the Michigan Department of Corrections for 13 months to 48 months with credit for 24 days served. And as to the monies that are due, those will be due 1 year after your release on parole. And I'm waiving fines, costs, attorney fees, and while you're incarcerated, I just send a message. I know you're doing all this, but you should participate in domestic violence, anger management, treatment, cognitive behavioral, complete your GED and attend AA, NACA, no contact with the victims, and attend trade school and culinary arts if that's what you want to do, or any other trade school. You have 42 days to appeal and to request appellate counsel, and your attorneys will send that to you with the proof of service to us. Do you have any questions, sir?
Yes, dude, that's running concurrent with my sentence I'm doing right now.
Thank you. It's going to run concurrent with the MDOC sentence you're serving now, which is 24248 FH.
Okay, yep, and I have nothing else. Everything that you named though is what I'm already doing through.
I know, I just say it, and then if there's any problem, sometimes there's a problem with people getting in or doing whatever, so I just say it, and then you do what continue the good work you're doing, appreciate your changed mindset, and look forward to seeing you back in our community and keeping it safe. Good luck to you, sir.
Thank you, Your Honor.
Thank you, that's all for this record.
Hey, Your Honor, can I please tell my counsel, can they mail the paperwork over to me?
They're going to, yes, that's their obligation, they know, they're gonna send it over to you. Thank you.
All right, thank you.
And now we are back on the record.
Okay, I'm sorry.
It's okay. We are back on the record on people of the state of Michigan versus Kendrick Campbell. And sir, I'm just gonna remind you that you have been sworn, and I did swear you, I get to that point, yeah. And then, is there medication you're supposed to be on that you're not on?
No, you're not.
Any sign of fever, COVID, or other illness?
No, you're not.
And you have spoken to Mr. Jackson?
Yes, ma'am.
And you remain happy with his representation?
Yes, sir.
And you've also read the pre-sentence investigation report?
Yes, sir.
And you pled to child abuse, fourth degree punishable by 1 year, assault with intent to do great bodily harm less than murder or by strangulation punishable by 10 years, and assault with a dangerous weapon, also known as felonious assault, punishable by 4 years. Do you recall that?
Yes, sir.
All right, thank you. Any corrections, additions, deletions on behalf of the people?
Your Honor, we had already made that one correction off the record. And then.
And just for the record, the correction that we made is on page 2, under description of narrative offense. The first full sentence was deleted in the third paragraph. That first full sentence is deleted, and then it's replaced, more accurately reflected is Mitchell reported they argued about defendant's infidelity. And counsel stipulated to that, is that correct?
Correct, Your Honor.
Yes,
All
sir.
right, thank you. And are there any other corrections?
The only, it's a brief typo, Your Honor, number 16 of 16 in the criminal history. In the arresting agency department is spelled incorrectly.
I'm correcting that, okay, thank you, good catch.
And no other changes to the body, Your Honor.
Counsel, any changes to the body other than the one we did?
There are typos under the description of the offense, just spelling Mr. Campbell's name without the P on at least 3 times, starting in the 4th full paragraph, there's 2 of them in there, and then in the 5th paragraph, there's at least 1. So 3 typos.
Yeah, I see them. Geez. Yeah, they spelled it both ways, didn't they? Yeah. All right, so I found 6 places where they did it wrong. Oh, and then they, and one of them in the 3rd paragraph, 3rd line, they added, oh no, they did that right. Okay. Okay,
I'm also seeing it spelled wrong at the top of page 3, Your Honor.
yeah, I'm just going there. Yeah, top of page 3.
Marriage narrative is spelled wrong, first sentence.
Where's that?
Marriage narrative,
Oh,
page 13 on mine.
okay. Yeah, first line under the marriage narrative, that's from. I don't know, in this day and age, we don't have typewriters, we have computers, you'd think that they'd figure that out. Any other place?
No, I have a couple other.
Okay, what are those?
The high school section on page 14, it says Sexton High School start date 2002. It's later than that. I don't think we can pin the exact year, just because we were trying to figure it out. And you can also see that contrast to the narrative part where it says Sexton from 1999 to 2000.
So, any idea what it is? You went to the high school for 2 years? You dropped out in 10th grade? Is that what happened?
11th grade.
11th, okay, so it says 10th grade, so you made it through 10th grade?
Yes.
Okay, you dropped, so you completed 10th, so that's right. So then you dropped out in 11th grade, any idea what year that was?
Not at all, Your Honor.
It's after 2002. It's definitely after 1999, which is listed in that next paragraph.
Right, so I'm gonna strike that, so I guess, did you do the math, how old are you now?
36.
Okay, so it would be 18, 20 years ago? Huh? 18 years ago, so
18 years ago, he would have been 18.
I believe it'd be 2003, based off of my calculations of his birth date.
Okay, so start date would be 2003?
I think it'd be 2003 to 2006, based off of my
Okay,
calculations.
let's just do that, it's closer anyways than what they've got. Is that okay, council?
That's okay. And last thing I have where it reads health, mental health, no mental health issues found by the defendant. He's been diagnosed with bipolar and ADHD.
And he's on medication for that?
Yes.
Okay, so I've just changed it to diagnosed with bipolar and ADHD and reports being medicated for those issues. All right. Anything else?
No, you're on.
Scoring.
Yes, Your
Oh,
Honor.
wait a minute, and then psychiatric history, it says no on the cover page, so we change that to yes.
Correct. Your Honor, I do have one more thing. I'm
Yes.
sorry. The page 1 of where it has prior convictions, prior record.
Yeah.
I have 3 prior felonies. He did have juvenile adjudications, but I don't think that's included in the conviction section.
It says juvenile record, yes.
Right, but I think they counted possibly a couple of those felonies in the felonies section,
Oh, okay.
but those were adjudications. And the misdemeanors, it reads 13, but I counted 9.
What happened to people? What should felonies and misdemeanors be? Do you agree with the 9?
I'd have to recount them again, Your Honor, if you give me one moment.
Looks like as a juvenile, he had misdemeanors, but then he also had some felonies. So-
Correct, Your Honor. He's got 4 misdemeanors as a juvenile and then 2 as a juvenile, 2 felonies as a juvenile.
Okay, so what should the correct number be?
I believe they counted those as the felonies and the misdemeanors. So I think the correct number would be 3 felonies, 9 misdemeanor convictions, and then juvenile record, yes, which I would put all those in there.
People agree?
I would say there's 9 if we're not counting the juvenile. I do believe the juveniles should be counted, Your Honor. As it does say juvenile record, yes. So I do believe that they should be counted, but obviously I'll leave that in the court's discretion.
Okay, thank you. Next, changes.
Alcohol on that same page, 2001, has no end date. The end date would be 2025.
Next,
That's all I have.
how about scoring?
Yes, Your Honor. OB 12 on both the assault with intent to do great bodily harm, less than murder, as well as the felonious assault, are currently scored at 0. I believe they should be scored at 10 points, Your Honor. OB 12 specifically is in regard to contemporaneous felonious criminal acts. 10 points would be either 2 contemporaneous felonious criminal acts involving crimes against a person, or 3 or more contemporaneous felonious criminal acts involving other crimes were committed. Your Honor, we had dismissed 2 felonies against a person, the unlawful imprisonment and the domestic violence, and then dismissed the witness interference, Your Honor, 2 counts of witness interference. So I do believe that OB 12 should be scored at 10 points.
Any objection?
No objection.
Both, on both counts, the 12 is now 10. That takes the OB level up to, unless there's other changes, up to 40. What level is that?
That is still the same level, Your Honor.
All right, so Are there any other corrections on behalf of the defendant?
I do have one more correction, Your Honor, not to the assault with intent to great bodily harm, but the felonious assault.
Okay,
OV1 is currently scored at 0 points. OV1 is in regards to aggravated use of a weapon. I believe it should be scored at 15 points. It specifically states that a firearm was pointed at or toward the victim, or the victim had a reasonable apprehension of an immediate battery when threatened with a knife or other cutting or stabbing instrument. Your Honor, if you go back to the description of the narrative.
yeah, I read it.
Yes, where it specifically states that Mr. Campbell held a knife to the victim's throat and live streamed it on Facebook, and could hear Mr. Campbell stating that he was going to kill the victim as well as himself, and that he did not give a fuck about people seeing it on Facebook Live.
Change has been made, counsel, do you have any objection? Or you would like to make a record for appellate purposes?
No, Your Honor.
Thank you, change has been made, that means it's 55, what is does that change the level to 3?
That does change it to 3, and that would change the guidelines of 12 and 24, Your Honor.
So I've changed that on the basic information sheet, so everything is consistent. Let me look under the narrative about this and see. So the recommendation narrative. Let's see. I'm changing the 10 to 23 to 12 to 24, it's on the first line. And the rest remains the same. All right. I think everything's consistent. Do we have a victim here?
I believe she's on Zoom, Your Honor. I'm not sure if she wishes to make a statement.
Did you have something else, Counsel?
Yes, Your Honor, I have a couple guidelines.
Oh, all right.
Thank you. OV10 is scored at 10, and that's exploitation of a vulnerable victim. I believe they scored 10 for exploiting a domestic relationship. They were in a domestic relationship, but I don't think there was any exploitation besides that there was an assault that was had that raises to a scoring level because Mr. Campbell did not exploit the victim's physical disability, mental disability, youth or age, or domestic relationship. When I hear that, I think of something like a person, is reliant upon money or
Yeah, I think.
anything like that.
And you can disagree with me, I don't know what the people's position is, but I think what they mean is because he was able to get close to her because of their relationship, so that's exploitation of that domestic relationship, getting close enough to her to assault her where she doesn't expect someone who loves her, is in a relationship with her to assault her.
I would agree with that, Your Honor, especially given the fact that this assault occurred while she was holding their child in common.
So, denying that you made your record for appellate purposes.
And one more, Your Honor.
Yes.
OV19 is scored at 15. I think it should possibly be 10 because OV19 for 15 would be use force or the threat of force to, I guess, avoid the penal institution, but I don't believe that was the case. I think that's scored for possibly calling the victim, and that's not force or threat of force.
Response?
Your Honor, if you look at the narrative, it specifically states he made repeated threats that he would kill himself if the case was not dropped, and that he would leave her forever if the case is not dropped.
All right, it's 15, you made your record. As the victim.
Yes, Your Honor, I do believe she's on Zoom. I'm not sure if she wishes to make a statement now or not.
All right, Ms. Mitchell, do you wish to make a statement?
Yes.
All right, please raise your right hand. Do you swear or affirm the testimony you're about to provide me the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
Thank you. Put your hand down. Please state and spell your name for the record.
Serena Mitchell, SARAYNA, Mittchell.
Thank you, and ma'am, we are on Zoom, so be especially aware that sometimes it has little blips, so I need you to pretend you are reading to a 5-year-old and not speedily go through, even though you might be nervous, just pretend you and I are, there's nobody else in the room, you and I are having a cup of coffee and just talk in a normal space, can you do that pace?
Yes.
Okay, very good, you may proceed, what would you like me to know?
I have to turn my camera off to read this statement from my notes. Is that okay?
Sure.
Okay, thank you. Okay. It took me a long time to accept that I was a victim. For years, I was manipulated, controlled, and made to question
Wait,
my own reality.
ma'am, I
Yes,
need you to
yes,
enunciate, the court reporter's not able to understand you, so stay closer to the microphone and just try to enunciate so we get through this quickly, okay?
yes. It took me a long time to accept that I was a victim. For years, I was manipulated, controlled, and made to question my own reality. The description he gave that I was simply thrown down by my throat while holding the baby isn't even close to what happened that day.
Description he gave, what did you say, the description he gave about?
I was simply thrown by.
Thrown down by my throat while holding the baby does not come close to describing what happened that day. Before that, I had been slapped in the face, punched repeatedly in the head, chest, and shoulder, shoved around, and called names. He also stated he did not strangle me to the point that I passed out, but he did a few times. The violence escalated after I confronted him about his infidelity with another man. He also tore kitchen drawers from their tracks, threw food and dishes throughout the house, and punched holes in the walls. All the noise woke up our 4-month-old son, Kellen. I was standing with Kellen because he was crying, and even though I was holding the baby, he still hit me and I fell, somehow managing to protect Kellen's head with my hand as we both fell down. Thankfully, he was not injured. I remember being terrified. At one point, he was holding Kellen.
Wait, she remembers being terrified, at one point, you may proceed.
He was holding Kellen while telling me everything was fine, but continued screaming. So I ran to the front door trying to leave, but I had no phone and couldn't get myself to leave my children behind. I was trapped between my own safety and their safety. Moments later, he pushed me into the fridge and strangled me while he held my baby on his hip. The last thing I remember before falling down was looking into my baby's eyes and wondering if I would ever see him again. That moment has stayed with me ever since. For weeks, I struggled to look at Kellen because seeing him reminded me of the fear that I felt. I struggled to care for him the way I wanted to because I was overwhelmed by the trauma. Kendrick went on Facebook Live threatening to kill himself while holding a knife and placing it against my neck. I didn't know whether he intended to carry out those threats. I feared for my life and for the safety of my children. Eventually,
Last sentence again.
That last sentence, please read it
I
again.
heard I feared for my life and the safety of my children.
Yes, thank you.
yes. Eventually, he's the one that called 911 and told them I was mentally unstable and kidnapping his children. That was the best call he's ever made. It was the beginning of the end of the abuse. It gave us the intervention and gave me and my children the opportunity to be safe. The effects of his actions continue to impact me every day. I had a mental health stay after everything happened. The fear, anxiety, and trauma did not disappear. It's changed the way I view relationships, trust, and my own safety. It's affected my ability to parent, to heal, and to move forward. His actions rob my children of the father they deserved. They will grow up carrying the consequences of choices they never made. No child should have to live with those memories or that loss. I hope while incarcerated, He has the time to learn to love himself and accept that he is a bisexual man and will no longer feel the need to abuse women to make himself feel better. Today I'm here because I feel that I will not stay silent. Speaking has not been easy, but it was necessary. I'm proud that I have found the strength to protect myself and my children and to tell the truth. I'm a stronger the women than he expected, and I can't be convinced to stay quiet. My hope is that the court fully understands the lasting impacts he's had on my children and my life. Thank you, Your Honor.
Thank you. On behalf of the people, or ma'am, let me just say, you're very strong for coming forward. I'm gonna have a no contact order with him and you and your children, and you should really.
He's continuously violating that and using a third party also.
Okay, so what I need you to do is let me know. I will call the warden, and then he will not have any communication with anything. People will have to come see him. So I need you to just keep me informed, please, and contact the warden as well, all right? So I'm gonna order no contact, and I wasn't aware of that, but nonetheless, you need to please let me know and let the warden know, okay? And you should really be proud of speaking on behalf of yourself and your children. And are you asking for any restitution for therapy or any other costs?
No, Your Honor.
All right, well, ma'am, I hope that you seek some therapy so that you realize that you are strong and that you didn't do anything wrong and you deserve roses, not bruises. And regardless of your relationship, this clearly was not a good relationship, and that is on him, not you. It sounds like you did everything you could do, including raising the children you had together, and you certainly did not deserve this or do anything wrong. So look in the mirror every day and tell yourself that you are strong, you are a warrior, you will protect your children, and you just need to get better and better. But I think some counseling is warranted. If you would like me to keep this restitution open so he pays any co-pays for that, I'm happy to do that. It's gonna take a long time for you, I think, to heal and to understand how worthy you are and how much you deserve love. And this is not love, and ma'am, it's a trauma that lingers. So would you like me to keep? All right, so I'm gonna keep restitution open. And then if he disputes any amounts, we'll have a restitution hearing, but that certainly is your right. All right, and I think it's wise so that you have somebody who's your secret keeper who you can deal with this, because I can hear the trauma, and also I can also hear the strength. So you need to get stronger and stronger every day, and you might need some help to do that. So really appreciate you being here. So many people who are victims don't come, and you're really an example for your children, your community, and all those who just feel they can't come forward. So thank you.
Thank you, Your Honor.
Your Honor, I do believe that Miss Mitchell's mother is also here and wishes to make a statement.
All right, could you have a seat, please? Ma'am, please raise your right hand. Do you swear or affirm the testimony you're about to provide be the truth, whole truth, and nothing but the truth and the penalty of perjury?
I do.
Thank you. Put your hand down. Please spell your name for the record.
Rayla, R-A-Y-L-A, Brown.
And what would you like me to know, ma'am?
Actually, really hard to encourage the relationship for my daughter and my grandkids' sake. As the mother, I woke up 4 hours away to missed calls and text messages from my daughter's sister about the Facebook Live thing at 6 o'clock in the morning. As a mother, 4 hours away, and this is what I'm fear, and I don't know what's going on. I have to call the local police department, ask them to do a well check, only to find out they're already there. Rush home. And a week later, I get a call from my kid trying to kill herself. Because she also found out that on top of everything else, the bills weren't paid. They were about to be evicted. So her father and I and her sisters paid her rent for a few months and helped everything until she could get fully on her feet. I just want to take into consideration the impact, not just on her. Like, she's moved hours away from Lansing now and taken my grandchildren, which these are my babies that I saw every day, due to consistent harassment from his family and friends, some here now. So she's left. That's going to affect my grandkids' future relationships with all of their family.
Well, that's on you, ma'am. I
Yeah.
mean, you can drive, you can have a relationship
do.
with them, and hopefully
do.
they can come back, but
Yes, but if this hadn't happened, we wouldn't have to. But these kids now are not gonna go father, which is really sad.
ma'am, you don't want them to have an abusive father because they will decide in their own brains that love means a fist. And so this is not a relationship that should continue because I see.
Oh, I didn't want it to. Oh, no.
Okay.
That was not what I was saying.
Okay,
Oh,
they're gonna
no.
grow up without a father who's abusive, and that is just perfectly fine because they have a loving grandma and other family. They need to learn what love is.
No, that was not what I was saying.
Okay.
So in the beginning, I tried really hard to
Yeah.
like him and work through this, but I just want the kids to be taken into consideration too, even though they technically weren't the victim.
They are victims.
In the end, not just his biological children, but my other grandchildren that he was around for years, that he loved so much, I wanted to take care of.
There's gonna be a no contact order. If he violates that, I need to know, and the warden will know, and then no one will be able to have communication with him through email, letters, etc. They'll have to go in person, so we're gonna watch that because he should not be around. And there's going to be a no contact order for him to not see your daughter or the children. It's not safe.
While he's incarcerated or after?
While he's incarcerated, I hope the warden also honors that after, but you can also get a personal protection order. We've made a record here, and I don't know if he's gonna be rehabilitated or not. His incarceration, she could choose to terminate his rights. I don't know if she wants to do that. You need to talk to a lawyer about that. The state is very unforgiving when it comes to criminality and non-payment of child support. So there's lots of things that can be done. You need to see an attorney who does family and criminal law with the circumstances here. I don't know if it's in the best interest of the children that those rights be terminated. But certainly if and when he wants to see the children, they would start out with supervised parenting time. I think that every family court judge, and I used to do thousands of those cases when I was in practice, and I was in practice in 28 different counties, and when it came to family law and criminal law, the judges start out for the safety of everybody with supervised parenting time just to see how it goes. Parental termination is alive and well in this state. There's been spelled legislation, there's lots of legislation that goes to this, so you all have decisions to make based on how well or how poorly he does. So you talk about that with your daughter and as a family, and I appreciate you being here. As it is, and I've done thousands of cases dealing with children and families, and grandparents step up to the plate. So I really respect that you have done that because you are that safekeeper of those children, a safe harbor for your children and grandchildren. And I appreciate that you are here because many people don't show up.
Can I thank you for my grandchildren? What is it?
Ma'am? No, why would you do that?
Without him, there wouldn't be them. It's the only thing he's done right.
You know, 5 minutes of fun in the South is a sperm donor. It is not a dad.
Oh, no.
Being an abusive dad, you're gonna thank him for that?
No,
I don't know.
For giving them life.
So he might be good for breeding, but that's it, it's a sperm donor. Do you think
exactly
sperm
what I
donors?
wanted.
I don't think so. You wanna do that, that's fine, but I don't think, it doesn't sit well with me, but that's your choice. It's, you know, I'm not gonna tell you what to do.
It's very unfortunate.
It is unfortunate, but the fortunate thing is that your grandchildren have a loving mother, grandparents, and other families, so they will know what love is and what abuse is, and that they don't deserve to be abused by anyone, especially a parent. So I appreciate you being here and being their voice. Anything else?
No, I'm sure you know how I feel.
Thank you.
Thank you.
Counsel?
Yes, Your Honor. Based off the statements that were just made by Ms. Mitchell and her mother, I want to make another amendment to the guidelines. OV4 is currently scored at 0. I do believe that OV4 should be scored at 10 points. OV4 is psychological injury to the victim, and OV10 is specific, or 10 points on OV4 is serious psychological injury requiring professional treatment occurred to the victim. You just heard, Your Honor, that this
That's with
is
assault with intent to create bodily harm, is that what?
on both the assault to do and on both, Your Honor.
Okay,
She's made it very clear, Your Honor, Ms. Mitchell, this has been a lingering, lasting impact on her mental state. She had to take an entire mental health day the next day. And you just heard from her mother that based off of everything, she attempted to commit suicide. I think, Your Honor, that very clearly shows that there was some serious psychological injury done to Ms. Mitchell by the defendant. So OV4 should be scored at 10 on both cases, on both charges, Your Honor.
counsel, response?
Thank you, Your Honor. We would object to that. Taking one day off the next day does not rise to requiring treatment. Thank you.
All right, OV12 is, it was OV12, right?
OV4, Your Honor.
I'm sorry, OV4 is 10 above, so that changes the scoring to 50 on one and 65 on the other. What is about the level and the guidelines?
That does not change the level of the guidelines for the felonious assault. However, Your Honor, for the assault strangulation, that does change it to a level 4. And that changes the guidelines to, one moment. That changes the guidelines to, I have 34 to 67, Your Honor.
Changes have been made unless you disagree with that calculation, counsel. I know you disagree with the overall what we're doing, but do you believe that's calculated correctly?
If that's the level and the.
Yeah.
I do have the guideline book if you want to.
Okay, changes have been made. And looking at the narrative and showing, changing it then to 34 to 67. All right, thank you. Anything else, counsel?
Your Honor, I think it's very clear here, and no other changes. So I think it's very clear here that Mr. Campbell did a terrible thing on that night. Not only to Ms. Mitchell, but his children as well, Your Honor. His criminal history shows that he is not, things are getting worse and worse and worse, Your Honor. There were previously just prior domestic violences, some malicious destruction, and then we get to here, Your Honor, where there were previous other DVs that were ultimately dismissed, and now we're here with this incident, Your Honor. Ms. Mitchell had mentioned that it was just this night itself, but I also want to make it clear, Your Honor, and I understand that we dismiss these things, but Mr. Campbell did bring forward, was calling her on multiple occasions after this incident happened and was trying to get her to stop, saying he was going to kill himself if she did not drop charges. I think those are significant. It just shows the controlling behavior of Mr. Campbell. And given the changes to the guidelines, Your Honor, I do believe I would not be following the recommendation by probation in this case. As guidelines, Your Honor, are now 34 to 67, I do believe it's appropriate to be on the high end of the guidelines in this case, given this situation, given everything that Mr. Mitchell has done to the victim as well as the family here, Your Honor. They are all suffering, and I believe that the high end of the guidelines would be appropriate given everything in this matter, Your Honor. And I normally don't do this. I do have that video of the Facebook Live video, if Your Honor wishes to see it. Okay, thank you, Your Honor.
Counsel, what would you like me to know?
Thank you, Your Honor. Okay, so it is easy to pile on a lot because Mr. Campbell did a bad thing on that day. So I'll just have to go through a few things. First is that his criminal history is, he has stuff on there, but when you really look into it, sure, there's bad things, but out of the 9 misdemeanors, 2 of them are a minor in possession, and 3 of them are traffic related. So, 9 is 9, but 5 of those are for, I would say, relatively minor things. Hurt people do hurt people. And just like, I guess, the court implied that the kids are, somehow by way of being around a victim. And in fact, one of them arguably is a victim because they were being held at the time. And that they grow up and they should know love. Mr. Campbell, he unfortunately didn't know that kind of love when he was a child. In the PSI, it reports that his dad abused him as a child and went to prison for that. It says that he went to prison, but it was actually for the child abuse when Mr. Campbell was a kid. And that's, unfortunate for Mr. Campbell. It's something that he has to live with and that he has been living with. That incident is unfortunate in a lot of ways, but Mr. Campbell pled no contest because he didn't remember that incident. He was intoxicated off alcohol at that time. And, even from the first time we spoke, he's like, no, I don't remember. I had to show him things, read things to him. And he's like, oh my gosh, can't believe I did that. And that's, it's no excuse that he was intoxicated, but it's not that it was his natural state. Since he's been sober, I think that when he's sober, I think that he's a very good and appropriate person. Yes, he did make those jail calls at the beginning of this file when he was in jail, and his phone has been stricken and revoked since then. He represents that he did not make calls after that, which I think there could have been some confusion on the timeline. So yes, he made calls, but not after that. Mr. Campbell hasn't been able to speak to anybody except for his attorney. And to the point where we found out from this PSI that his mother, his adopted mother, who's basically had him since he was a baby, it reads deceased. And Mr. Campbell is like, what, wait, is that right? Is that wrong? We can't even find out. There's nobody we can talk to even know about that, which just shows that Mr. Campbell is not communicating with people in the jail. Also, the alcoholism is important because I think that's the root of a lot of when he commits crimes. You can see the MIPs, there's OWIs on his record as well. It just shows that he's been dealing with that. He says that when things get stressful, that's what he turned to in the past. He's been in jail, Your Honor, as you can tell, for almost a year. I guess 316 days is what the PSI have. We have no reason to dispute that number. And that's a long time, especially when you're not able to talk to anybody. He has done things in the jail. He's been in the CATS program. He completed the parenting classes, Seeking Safety, AA, which is significant because, again, alcohol is an issue here. The case Financial Wellness, and Your Honor, I'm just holding up a couple of certificates here, one from the parenting program and one from the Financial Wellness program. And if Your Honor needs it, of course, we can hand it to you.
I can see it, I know what it is.
Thank you. And also something that was not discussed, that's important, is that Mr. Campbell is facing a federal flop for this. He is all but assured to do 2 years consecutive to your sentence, Your Honor. And that's nothing to, that's no, insignificant thing. 2 years is 2 years on top of the year he's already done. And plus, if he receives more, then that is a lot for, you know, his actions. He did what he did. He was intoxicated and did bad things. And there's just no way around it. It's unfortunate that one bad night like that could cost him all these years of jail and prison. Your Honor, he has 7 children and 6 children. And despite, you know, what it looks like on paper, he is a good father, except for the assault that he had recently. He doesn't have child abuse cases out of all his kids. He has a 17-year-old, a 16-year-old, an 8-year-old, a 13-year-old, and then the 2 here, which is a 2-year-old and a 1-year-old with the victim in this case. Mr. Campbell, with 5 out of his 6 children, he had custody and was caring. That he's not just a complete absent father like was almost represented today. He does have custody. He is loving and caring of them, and he doesn't have crimes against those kids, minus this child abuse 4th degree for the child being in the vicinity. Mr. Campbell has suffered a lot. The victim has suffered, and now it's about what should happen. I think that Mr. Campbell, no matter what happens, is going to be penalized severely. Again, he's already been in jail for over 300 days. He's looking at 2 more years, no matter what Your Honor does. And we would ask that you not go to the top of the guidelines. The guidelines here are, you know, all the things that we corrected are already accounted for. Having a knife, added stuff, psychological injury, all these things that the prosecutor argues for reasons to make it way higher are already accounted for to make it where they are. So we ask that you not do that for Mr. Campbell. He is salvageable, Your Honor. He will be out of jail and prison one day, and he will still be a father to these kids, whether he's in prison and when he's out of prison. And we ask that you consider his background. He does have mental health diagnoses, and it would be unfortunate to have Mr. Campbell, who I think will be a good guy, is a good guy, and once he gets out, will show everybody what he's capable of. And we don't want to see him go down for longer than necessary, Your Honor. So please consider a incarceration sanction, if Your Honor feels that's appropriate, with the knowledge that he is going to be federally flopped from this and have to do federal time once his state time is over. Thank you.
Just in response briefly, Your Honor, I don't see anything in the PSI about this federal flop, so I'm not sure where that information is coming from.
Was he on parole?
Yes, Your Honor.
Okay,
I was on federal supervision, Your Honor. I did 2.5 years in federal prison, and I came home in 2022
so you're still on.
on supervision. Yes.
Okay. Sir, what would you like me to know?
First of all, I want to apologize to the victims, Serena, and my children. While I'm incarcerated, no matter what time I get, I'm gonna do better myself. That's it.
Sir, your criminal history is horrible. It's not the worst I've seen, but it's violent. You are a violent drunk, and this is a domestic flirt, so it's not a question of, oh, this is the first time, it was a little argument. It's not the worst record I've seen. There's some driving on license suspended. I feel like half the county has that. But you have operating while intoxicated. You have domestic violence first and second. You have crimes that are assaultive, including police officer assault and resisting. And so there's a lot going on here. And to assault the mother of your child is greatly offensive, especially when your child is there. A defenseless child who can't speak up for themselves. And you know, it's interesting, I rarely have mother-in-laws saying, I was rooting for him. And the grandmother is here saying, I was trying to keep this family together because family's important. And you didn't honor your family, and you didn't honor her family, who was in your corner too, rooting for you, despite all this background. So you need some help. You need to figure out what demons you have, what past traumas you have, and get the help you need. It has started, you've completed some classes, but you got a lot more work to do, because ultimately, you're lucky you didn't kill someone. You're lucky you didn't seriously hurt her where she's in a coma, loss of limb, or some issue where she couldn't take care of the children, because you can't take care of the children. They'd be left to be raised by grandma and siblings. You have to prioritize the safety of your family. If you're not prioritizing the safety of your family, you've not only let yourself down, but let your community down. And as I said, this state is unforgiving with parents who are incarcerated. Parental termination is alive and well in this state. The state does not tolerate parents who cannot be appropriate with their children, who are not fit parents. So I don't know what's gonna happen here. But there is a possibility, and I want you to seriously get rehabilitated, take it very seriously so this never happens again, because otherwise some other man can raise your children. And I can't think of anything worse. Incarceration is not the worst thing. Parental termination is. And then maybe if your children aren't mad at you when they're 18, they might decide to come looking for you. And you can say, well, that won't happen to me. I've seen it happen thousands and thousands of times. Sometimes I represented someone like you, and sometimes I represented the children. Sometimes I represented the grandparent or the mom. Regardless of who I ever represented when I was in practice, these are tough, sad cases. And they happen every day downstairs in the family court. So if you don't believe me, zoom into one of those hearings, or when you're out of custody, go in as a reminder, or talk to your attorney. We've all seen it. Those are the worst cases, because everybody suffers, and your children will wonder, why didn't dad want me? Where is my dad? Why can't my dad come to the ball game or the graduation? As to count one, child abuse, 4th degree, you'll serve 316 days of credit for 316 days. You'll pay a $50 state cost. As to count 2, assault with intent to do great bodily harm, less than murder by strangulation, you will serve 48 months to 120 months with credit for 316 days served. You'll pay $130 crime victims and a $68 state cost. As to count 3, assault with a dangerous weapon, also known as felonious assault, you will serve 24 months to 48 months with credit for 316 days served. You'll pay a $68 cost for each of the felonies and $50 state cost for the misdemeanor, and $130 crime victims. Those will be due 12 months after you are released. These counts will run concurrent, and while you're incarcerated, you will participate in cognitive behavioral trauma counseling, anger management, domestic violence as a victim and as a perpetrator, trade school, and substance abuse treatment. I'm leaving restitution open for 1 year, or if counseling continues for as long as counseling continues, and you will have to pay the copay if there is any. Additionally, you will pay for a copy of the transcript, the sentencing portion of this, which will be sent under seal to the victim, so she can use this in treatment and her own therapy, which I do find useful, so the therapist will understand what has happened here. You will not have any contact with the victim or the children you and she have in common. As to child support, I don't know that you have any ability to pay. You'll have to deal with that, but you'll follow all family court orders. And sir, if you decide to contact them, I will contact the warden. No contact means they don't exist in your world. No Christmas presents, Hallmark cards, flowers, smoke signals, messages through third parties. No emails, texts, no communication. Understand what no contact means?
Yes, Your Honor.
And that would be with both victims as well as any children, other children you have in common. If you disagree with the restitution amount, you contact Mr. Jackson and he'll request a restitution hearing in front of me. And then I will determine the amount. It can go up, it can go down. You have 42 days to appeal and to request appellate counsel. Is there anything I failed to address?
The only thing, and I believe they would be concurrent, but you're saying that the assault, the strangulation, felonious assault are concurrent with one another?
Yes.
Okay, thank you.
However, they would be consecutive to whatever federal sanction there is if.
Yes.
So and I don't know anything about that.
Thank you, Your Honor. First, I'm handing Mr. Campbell his appellate rights paper. And second, he currently has, again, at the Ingham County Jail, no calls, can't even use the phone. He's requesting, while he's still there, before he gets sent to MDOC, to have one phone number to be added, to have him allowed to speak. And it's a lady in the courtroom, a friend of his, and he has the number. I think that is something that we could do for him, since again, he's had no contact. He can't.
Excuse me, Your Honor, can I say something?
What would you like me to know in regard to that?
The woman's phone number that he wants in the courtroom has been stalking me from other Facebook pages and messaging my girlfriend.
Okay, so if that happens, that's a third-party communication to you. And
Yes, that was
certainly-
that was my birthday on June 11th.
Just a minute. So if there's stalking behavior, you need to make a report to police and also to the prosecutor's office, and there are other charges that can be filed. So I would ask you to document that and contact law enforcement, please. On behalf of the people, and where is this woman? Ma'am, please come up. Please step aside, Counselor. Raise your right hand. Do you swear or affirm the testimony you're about to provide me the truth, whole truth, and nothing but the truth?
Yes, ma'am.
Ma'am, if you interrupt me, I will give you contempt. It's 93 days, $7,500. So you wait till I finish a sentence, and I'll wait till you finish a sentence. Is that okay with you?
Yes.
Thank you. Please state and spell your name for the record.
Tanya, Tonia, last name Wooten.
Ma'am, do you have any felony record?
No.
Are you on probation or parole?
No.
And is there any reason you can't go to the Ingham County Jail to visit him, or to the Department of Corrections to visit him?
Nope.
So do we need to have phone calls?
Yeah.
Why?
Because why shouldn't I? I was
Well,
with Mr. Campbell for 6.5 years before he got with Serena. She convinced him and
I don't want to hear anything about it.
Well, of
ma'am.
course.
I'm talking about the two of you and Ma'am, the issue is now I have allegations that you've been contacting her, and I don't think that we need to make this any more messy than it is, do we? Do
She's
you want,
messaged me too, ma'am, to third parties. She's not innocent.
have you ever heard of blocking? Y'all need to block each other and
Yeah,
call law
I blocked her.
Okay, very good. I'm not going to allow any additional contact. You can see him in person.
Okay, that's fine.
Thank you. Good
Yep.
luck. Anything else?
No, Your Honor, thank you.
No, Your Honor, thank you.
Thank you. That's all for the record.
Bye, Kendrick. See ya.
I didn't either.
No,
Nancy did.
what? No. Yeah.
Food, lunch.
Now it's supposed to be going.
What else have we got?
So it is 12:20, Your Honor. I'm not sure if we want to continue.
How many more do we have? What do we
We
have?
have a bond hearing, we have a sentencing with the AG.
And then we're done?
And yes, and then there's the Graham's case, but that won't be until 3.
Okay, we're gonna do those two or you wanna take a break?
Can I just go?
Yeah.
After, and then we'll do one?
A couple minutes and then get ready for those two cases.
Who first?
We're going to do Ms. Sova first, Archie Sova. Yes, I was like, well, then my AG, so the AG right after this.
Okay.
He's gonna leave it.
She probably knows me there.
Yes, it's all set. Yes. All right, yes, I talked to Oprah with Judge.
record?
Good afternoon, Your Honor. APA Bart Buxton on behalf of the people of the state of Michigan.
And thank you, Your Honor. Jonathan Foreman, Office of the Public Defender, here with Mr. Sova, who is seated to my left.
Thank you. If you could approach the podium, is that acceptable?
Judge, he has some medical issues.
All right, that's fine. Sir, please raise your right hand. You swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury.
Yes. And Your Honor, I'll just note he raised his left hand due to the medical issues that
That's
prevent.
fine.
Thank you.
All right, sir, have you taken medication?
Yes.
And with the medication that you're on, are you still able to understand your attorney or this court?
Yes.
All right. Is there medication you're supposed to be on that you're not on?
No.
Any sign of fever, COVID, or other illness? And counsel, you believe is oriented to date, time, and place?
Yes, Judge.
All right, thank you. So this is a motion to modify bond.
Yes, Judge.
You may proceed.
Thank you, Your Honor. So this is a case that's currently pending on appeal. The Court of Appeals determined that the contraband in this case should be suppressed, which would have essentially got the people's case. They would not be able to proceed. They have filed an application for leave to appeal to the state Supreme Court, seeking reversal of that Court of Appeals opinion. But in the meantime, Mr. Sova is subject to bond conditions. He's required to report to pretrial services monthly. He's subject to testing. He has firearms restrictions, things like that, that interfere with his liberty. If the Supreme Court were to reverse, for example, they just released an opinion yesterday that came 2 years after the Court of Appeals opinion was released. This has the potential to go on for quite a while, all while Mr. Sova is subject to bond conditions for a case that, in all probability, is not going to be proceeding. So that was the reason why the defense filed its motion and seeking that those bond conditions be removed. Thank you, Judge.
Which bond conditions? All of them? You don't want him in bond while we have a pending case? I mean, I'm sorry about the length of time it takes in the appellate court. It's not my problem. They don't have the same restrictions for time that we do, but I'm not willing to just dump it on an if.
Specifically, Judge, related to use of alcohol, marijuana, controlled substances, related to possession of firearm or other dangerous weapons, the subject or condition use subject to testing, as well as reporting to pretrial service.
Denied. This is for public safety, safety of the victim. I don't know what they're gonna do or not. I haven't heard anything that it really impinges on his life. The allegation is meth. Meth is very dangerous. And on bond conditions, there are no weapons. You can't use drugs or alcohol. I think this protects not just the community, but also your client, because if there's other allegations, that's problems. So I don't see anything that's really impinging his life if he wants to not appear in person, but appear over Zoom, so he doesn't have to, especially if he's got illness, report to pretrial services on Zoom or telephone. I don't have a problem with that, but I'm not gonna amend anything that I don't see as impeding his life. It's not my problem that the Supreme Court takes this long in the Court of Appeals. I apologize to everybody for that. I have no control over that, but bond conditions are bond conditions. It's for safety of the public, and your client is part of that, as well as him appearing before the court, which he's always appeared, so I don't have a problem with that, but public safety, and there's so much meth in this community. It almost was eradicated several years ago. Now it's almost every other case I have a case of meth, so I'm denying this. Any comment from the people?
The people are in agreement with the court, Your Honor. Thank you.
Thank you.
Thank you, Your Honor.
That's all for the record. Next case.
Yes, Your Honor. Ruben Martinez.
This is docket 261635 FH and 261639 FH, People of the State of Michigan versus Ruben Martinez Jr. Counsel, your appearance for the record.
Good afternoon, Your Honor. Mark Gabriels, Assistant Attorney General on behalf of the people.
Good afternoon, Assistant Public Defender Sarah Donnelly on behalf of the defendant Ruben Martinez, who is standing to my right.
All right, I should note that it looks like on the 261639 FH, I just looked at that and, because I wondered why it was here, I did sign a nollie, so that's technically not in front of me. We are here for sentencing on 261635 FH. Sir, please raise your, is that correct?
No, Your Honor. My understanding is he pled guilty to one count in both cases, and the balance of 2 counts were dismissed in both cases.
That is true, Your Honor.
So, do I have a nollie on, yeah, the third one? Why is there a nollie here?
It would be on counts 2 and 3 of both cases.
Okay, I have a nollie on counts 1, 2, and 3 on docket 261639.
On docket, what's the?
Counsel, please approach. Maybe that was a typo, we need to fix that, I don't know.
Yeah, that's.
So
Can I do it, is
the
it?
motion in the case counts 2 and 3.
Oh, all right, okay, I just didn't read far enough, so 1 is standing, it's 2 and 3, I got you, okay. Thank you. Okay. So, I'm sorry, did I swear you, sir? Please raise your right hand. Do you swear or affirm the testimony you're about to provide me the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
Put your hand down. Taking any medication yesterday or today?
No, ma'am.
Any sign of fever, COVID, or other illness?
No,
Is there medication you're supposed to be on?
no, ma'am.
And sir, you have 2 counts, 1 in each file of failure to pay child support, each punishable by 4 years. Looks like at the time of the plea, the balance on 1635 that was due was $8,530.21. And on 261639 FH, it's $14,350.09. Are those paid down or are the numbers changed?
The numbers have changed slightly, Your Honor. The report I had was as of the 24th, and both amounts have gone up slightly. This morning, Ms. Donnelly showed me a receipt that had paid $150 towards at least one of the cases. So I can give you the numbers as of the 24th if the court would
Well,
want.
we could just leave these then. I just didn't know if he paid it down enough so we could deal with this otherwise, but that's fine. We'll leave that to the front of the court.
Both have gone up by a few $100s as of the 24th.
All right, thank you. Any corrections, additions, deletions?
Your Honor, I would note, Ms. Donnelly pointed this out, on the basic information sheet, it said that the defendant was represented by Sarah Brenner. That's the Assistant Attorney General in this matter, so with that change to be changed.
Was she there for plea?
Yeah, she was the AG at plea.
She was the AG at plea?
I'm the defense attorney. For some reason, he put down Brenner's name when it should be.
Oh, okay, so Sarah.
And it's, everywhere, yeah, on the first page where it said every attorney.
So let me correct that everywhere. All right, so basic information sheet of both counts and changing it.
Yeah, the next page, it says her top.
And then the recover page is probably under evaluation plan.
Yes, I think that would be the last instance.
Okay. Okay, correction has been made. Any other corrections?
Not for the people, Your Honor.
Counsel?
Your Honor, only on the first 2 pages where it says jail credit, it says 0. There is a jail credit on page 2 of the recommendation that does say 65 days, so I do believe the jail credit should reflect that.
Any
On all
objection?
pages.
No objection, Your Honor.
All right, let's change on the cover page and let me see on the basic information sheet, did they note that as well?
No. Or no, they did in recommendations, yes, they do have 65 days credit for
Yes,
65
they
days.
didn't on the basic information sheet. So now on basic information sheet on both counts as well as both counts, the cover page has been changed to reflect what it is. And then let me see in the inside, hopefully they've got that correct as well. I don't know if they even addressed it, but who knows? Let me just double check.
They did address it and it is listed.
They did, okay, yeah, I do see it under recommendation narrative, thank you. As to scoring guidelines?
Oh, I had one more, Your Honor.
Oh,
Just
all
one
right.
more. And on evaluation and plan on the first page where the probation agent listed his scoring for the PRVs and OVs, he says OV 13 was scored 1 point, but it was actually OV 12. And that's it for me.
Is that under evaluation plan, what paragraph?
The last one at the bottom of the page, yes.
OV 13 was scored at 1 point, and what should it say?
It should be OV 12. That's what's reflected on the
All
last
right.
page.
Changes to made, thank you. And that's the scoring, any changes?
No, Your Honor.
Nothing to scoring.
Is there a victim here?
Not that I'm aware of, Your Honor.
Thank
Neither
you.
have been contacted our office.
On behalf of the people, what would you like me to know?
Your Honor, at this point, I would just request that you follow the recommendation.
Thank you. Counsel?
Thank you, Your Honor. Yes, we would ask that you follow the recommendation as well. We also want the court to know because it was expected of Mr. Martinez at the time of plea to have a job and start making payments. That he does, I can provide a letter I could give to the court that he is going to start working at BMG Construction on July 1st. It's a
BMG Construction, so I'm gonna put that on the cover page as well as under the employment history. If you just give me the details, let me get to that page so we can put that there. VMG Construction. What's the start date?
July 1st, 2026.
And that's current, and what's your position?
It'd be a laborer,
Labor. And what's your rate of pay?
16 to start off.
Okay. And have you reported that to the front of the court?
Not yet, no.
All right, you need to do that before you leave today, okay?
Yes, ma'am.
And it does say that under the employment narrative. It says, and that he may be able to be rehired soon. I'm just going to put.
That he may be able to what?
And that he may be rehired soon. I'm just going to change that to say, and he begins July 1st, 2026. There, now we're all current. On behalf of the people, what would you like me to know?
Just follow the recommendation, Your Honor.
Oh, Your Honor, and besides that, we also want to, there's the victim impact statements in the pre-SI. The court has probably read them. We just want the court to know that, and I've confirmed this with the AGs, that these victim impact statements were from the time of the investigation and they are not the current victim impact statements. I don't, if in case anything has changed, I know that Mr. Martinez has reported that he has since reconnected with his 16-year-old son, the one that he has with Priscilla. So I just wanted the court to know that.
Okay.
And besides that, Your Honor, besides that, Your Honor, the only thing is that in the recommendations listed by probation, in the numbered recommendations, not in the narrative, it asks, or it does list out cognitive behavioral therapy. At this time, Mr. Martinez is focused on working and his sobriety. He does a lot for his AA group. NA group. And
Well,
so,
cognitive behavioral should be part of that, so, okay.
well, as you're saying is that, on, Your Honor, we would only ask the court to consider, obviously, we're gonna send that for success. So that's the only, Your Honor, thank you.
Okay, thank you. Sir, what would you like me to know?
I think that's it, Your Honor.
Well, sir, you have, let me get back to this.
We didn't mention the tax garnishment.
Right.
He,
what?
He showed me proof. He submitted his taxes for the last 2 years. He's expected to get $7,700 back. And he's either, if there's there's a garnishment or not, it's going to child support.
Well, the state's gonna take it.
Exactly.
So they,
Exactly.
I'm sure, have already filed it.
Yes, so
They
that's.
should have, that's their protocol. If they didn't, that's on them, but I would hope that you would immediately walk that check down to the front of the court.
Yes, Your Honor, of course.
So, sir, you have a son, Ruben, are you seeing him?
I spoke with him on the phone. I haven't seen him yet.
Okay, so
he's-
you're connected with him?
Yes, ma'am.
Okay, he's 17, you can decide whether he wants to connect
Yes,
with you
ma'am.
or
Yes,
not.
of course.
What about Elias, 12?
I haven't, that's in the works. I need to.
What's in the works mean?
I need to go to front of court, establish, parent.
You haven't done that yet? When was the
No.
last time you saw him?
It's been a few years, Your Honor.
How many years?
Over 4, I believe.
Gonna be a sperm donor or dad?
A dad.
So he hasn't seen you since he was what, 8 years old?
Yes, ma'am.
Missed Christmases, birthdays, going from middle school to junior high, all those things you've missed.
Yes, Your Honor.
No good reason, sir.
None at all.
How about Gabriel?
I have custody of him.
Where's the mother?
She's in Lansing. She just chooses not to be a part of his life.
That's sad. So, is she paying you child support?
Yes, Your Honor.
Okay. Nice to get child support, isn't it?
Yes, Your Honor.
So you're receiving child support, but you didn't pay some child support. So you see how expensive it is to raise a child? That
Yes,
6-year-old is gonna need more and more and more and more, and it's on your shoulders, but at least you're getting some help from the mother. You need to help the mother of your children and pay your share of the support.
I agree, Your Honor.
Then ideal and evidence, let's get there. This isn't the worst case. I mean, I have people who owe $200,000 and $300,000 worth of child support. This is completely doable, but you gotta be employed, and when you're not employed, you go and be part of a work seek program. There should never be a time when you're unemployed.
Yes, Your Honor.
All right, you're going to be on probation for 36 months. If you want off, then pay, this probation is technically for you to be employed and to pay your child support. So I'm not gonna have you do everything that everybody does. But you're gonna do enough. I want the money paid. I want you to be clean, sober, and a fit parent. If you are not, I will stop parenting time immediately. Are there family court orders in regard to the parenting time with the children, all 3 children, or what?
There are court orders, yes.
And you're following those now?
Well, I plan to, yes.
So you haven't been following them?
The court order, I mean, I just haven't been practicing my parenting time with my middle child, Elise.
So, sir, when you were 8 years old, did you have a parent around?
I had a parent, yes, ma'am.
Did you have both parents or no?
I mean, yeah, my father was around. I can't say that he wasn't.
So how would you feel at 8 years old and not have any contact with your dad?
Not good,
And not for 4 years?
not good at all.
So your child is thinking, dad doesn't like me, dad doesn't want me. I am not all I can be because there must be something wrong with me because dad doesn't want me. You got a lot to fix, sir.
Yes, ma'am.
You'll be on probation for 36 months. You shall not use, possess, consume, purchase, or be in the presence of alcohol, illegal drugs, or drug paraphernalia. If you have money for those things, you have money to pay extra child support. If you have the need for any of those things, you'll present a prescription from a licensed medical physician within 24 hours. You will be tested if anyone believes that you are using illegal drugs or alcohol, any prescribed medication. You'll take at the rate prescribed. Over the counter, you can take, as labeled on the bottle, you can take less but not more. You will complete cognitive behavioral therapy. I think if it's recommended, or if you have issues getting parenting time with the family court, you ought to be in family counseling, and you'll have supervised parenting first with that 8-year-old, who's now 12 years old, because he doesn't know you, probably mad at you. So if it's warranted or requested by, it would certainly help you prove to the family court that you're a fit parent, is to go to some family therapy where he's included and where you have supervised parenting time, where you're watched and it goes well, and then you can progress to unsupervised parenting time.
Okay.
And you'll only have parenting time with any of your children as long as you are in good standing with this court, including the one you have custody of. If you are not in good standing with this court, we will make a call to Child Protective Services and see if you have a relative or neighbor who can raise that child until you are fit. This is very, very serious in terms of the issues that you're handling. This isn't just non-payment of child support, but you've got meth, cocaine, alcohol, and marijuana that you've been using since you were barely a teenager. So let's get a handle on all that. Have you dealt with any of the trauma in your background?
Yes, ma'am.
Okay, and you're doing okay with that?
Yes, ma'am.
All right, so, and are you working with CMH, or are you working with anybody right now?
I start with VMG on the first.
Great, so you'll work with them, including cognitive behavioral, and you'll continue, you're attending AA, NA, or CA?
He was referring to the
I'm sorry.
deployment, Your Honor,
Yeah.
Oh,
VMG.
VMG,
No, he-
okay, I'm sorry, so what about therapy?
No, I will be going to CMH. I've been to CMH before.
Okay, so work with probation to see if it's CMH or PATS or something else, is whatever fits you best. You need to do some counseling that perhaps your children or child can come in and all of that for the benefit of your family court case as well as this case. Let's get it all handled at one time. Because if I were your family court judge, I would have you and the child go into therapy and have supervised monitored parenting time and progress this slowly. So let's just tell the family court what you're doing. It's a lot better to come in and show them what you're doing and what you've done than have them order it. It just elongates it, and they need to know that you're fully engaged as a parent and that you want to be a parent. So let's get on that, sir. You'll obey all court orders and recommendations from all treatment providers, family court included, and probation. You'll not engage in any assaultive, abusive, threatening, or intimidating behavior, and you'll not use any corporal punishment for your children. You will not have verbal, written, electronic, or physical contact with anyone housed in the Michigan Department of Corrections or who is on probation or parole. If you need any contact like that, as long as everybody's doing well, then I'll grant you permission, but you have to ask for that through probation. You'll contact probation within 24 hours. Today, please counsel, direct him downstairs. One-stop shopping is always good. You'll comply with all written and verbal orders of probation. You'll allow probation to residence at any time for probation supervision without a warrant, and submit to a search of your vehicle, cell phone, residence, and computer. If there's reasonable cause to believe you have items that might violate the conditions of your probation. And these orders go to both files. As to each file, you'll pay a $68 state cost on each and $130 crime victims. Those will be paid after the child support, and this file will not be held open for those monies. The state will collect them when they do, but I'm not going to have late fees be imposed, so those monies will be due in 2030. So hopefully you can pay them now, but otherwise, I'm giving you time to pay the support and then time to pay those. I'm not going to have you pay probation oversight fees, finding that you're indigent for that purpose, because I want child support paid first. If child support is paid and everything's gone well, you can get off this probation early, otherwise I'll extend it to the full 5 years. You will serve 365 days jail, credit for 65 days served, the balance is held, I can use any or all of that time if needed. And that would be on both files. You will pay the arrearage and the ongoing support in the amount as determined by the friend of the court, and your wages, all jobs, wages, tax reports, whatever the friend of the court needs to calculate that child support, you will cooperate with. And it looks like and we've already read the amounts, but I know they've changed, but whatever is current on those files, you will pay. So you'll pay something toward what's due and then something toward the arrearage. And the credit court has a formula for that. If you can't afford what they say, you have a right to a hearing. So avail yourself of that. If your income goes up or down, avail yourself of, that's a change of circumstance, you let the friend of the court know. Otherwise, if it's too much for you to pay and you sit on your rights, it's just gonna accrue, and they don't go backwards and amend it, they only go forward. So if something changes, it's on you to let them know. You will have a wage assignment for your child support. This says if you miss 2 months, this is, you've already missed years, so no, you're gonna have an immediate wage assignment upon employment. If at any time you're unemployed, you'll participate in the work seek program. You'll not give your employer any cause to terminate you. You will work a minimum of 30 hours. You can work more, but not less. You will not use any object as a weapon, no ammunition, no imitation of a weapon. You will not be in the presence of anyone who has those items or any other contraband. If you have a use or a need for marijuana or alcohol, it will be by prescription only. And did I miss anything on behalf of the people?
No.
Any questions, sir?
No, Your Honor.
You have 42 days on each file to appeal and to request appellate counsel. Please give him his appellate rights. And then please go downstairs for probation. Set that up. Sir, if you miss any probation, you have to work overtime, or you're sick, or a child's sick or something, it's on you to follow up with probation or reschedule. You chase them, they don't chase you. Do you understand?
Yes, Your Honor.
Good luck to you, sir. You'll be on probation as long as needed to stay motivated to get it all paid off, all right?
Okay.
Good luck to you, thank you.
Thank you.
Thank you. This is docket 23-246 CE, Michigan Department of Environment, Great Lakes and Energy versus Paul Sokoviak, Priza Sokoviak, and PMP Contracting Services Inc. Counsel, your appearances for the record.
Thank you, Your Honor. Assistant Attorney General Gregory Justice, here on behalf of Eagle. I'm seated at council table with Assistant Attorney General Echo Allo and Amy DeSica, also from the AG's office.
Philip Ellison, appearing on behalf of all defendants, Your Honor.
Thank you. We have been in the back for, what, 2.5 hours or something, arguing any of the issues that will be coming before this court, and I know that we have an issue or schedule for a motion for stay, and I think an evidentiary hearing, and I don't know, a couple of different things, but it's very clear to me that there is a problem here, and the state has provided a lot of documentation. However, the issue of notice is not lost on me, and also the issue of liability is also not lost on me. Once there's an inventory done, it is clear that certain things have to happen, and the tax assessor must provide notice. I'm not quite sure that ever happened, and therefore, the court has requested that other parties be brought into this case, amongst other things. So let's go through. I'm simply going to turn right now to first to defendant in regard to the other parties who will be brought in.
Yes, Your Honor. I would make an oral motion to move to allow me to leave to bring in via third-party claims against the former owner, as well as the 3 local government agencies that as we discussed. And I would ask for 14 days leave to be able to make those filings, which will require the clerk to issue a third-party summons, which we will secure and serve upon them to bring them into the case. I'm reserving, as I've indicated, my ability to bring a motion to realign the parties as potential necessary party defendants, but we will deal with that once the parties are brought into the case as third-party defendants for the time being.
Thank you. And then on behalf of the plaintiff, there's a motion in regard to the site visitation and other issues. Would you like to make a record of that?
Yes, Your Honor, thank you. If I may, I did not see my other colleague, Assistant Attorney General Shady Weaver, also here on behalf of Eagle. I apologize to her.
No problem. Okay.
Your Honor, under the current situation, well, in light of the current situation, plaintiff would ask that we have the opportunity to access the property for the purpose of inspection, to make sure that the defendants are in compliance with both the law as well as the Judge Jamo's existing order. We would ask that it be that we would be allowed, Eagle would be allowed on the property with 72 hours notice.
And then that would be for inspection as well as soil sampling, and that would be not digging a trench, but rather digging, I don't remember what you called it.
Yes, Your Honors, it could be soil pits.
Soil pit, but you take the sampling, but then you refill it, so no, it's not creating a hole.
Yes, Your Honor, nothing destructive.
Judge, as I indicated, this would be consistent with Judge Jamo's current order right now. You reserved, as I understood our discussion, this would reserve my ability to bring an objection to it, but that objection needed to be reasonable in light of the court's direction as you provided to us.
So that you'll prepare that order 72 hours notice. You can take whatever soil samples you need, and in that fashion, if something greater is needed, you'll need to talk about it with counsel. If there's an objection, then I will deal with that, and anything that is done that causes costs to either side of you that is unreasonable for whatever reason, I need you to preserve it, and I will make a ruling as to who pays for the cost and any sanctions. Furthermore, in the event there's evidence that leads this court to believe that there is any interference with the wetlands, dumping or otherwise, the entire business will be shut down completely, 100%, until such a time that I am convinced that that is not occurring. So everyone needs to understand what can and cannot be done on that property, or the property will be shut down because I have that authority. We will not destroy wetlands. We will comply with the laws of the state. Now, granted, the legislature has not been very clear in terms of notice and all of that, but we're going to figure that out. And I understand the federal court is also looking at that. But it is also clear to me that there are a number of things that have fallen through the cracks. Once there was an inventory in 2007, there was not the tax notice, or allegedly not the tax notice liability for the wetlands. We're gonna figure out who should have done what, or who did or didn't do what, and who did or didn't comply. So we're going to sort through all of that, but I think it is important that these other parties be brought in. For documents that are not in existence any longer, we'll have to use the best evidence and perhaps some testimony, and look to see if it's credible or incredible, and then look to see what the various agencies have or have not done. And I think this is really important to proceed, not just for this case, but for all similar cases in this state. This cannot be the only one. And if local entities are supposed to provide notice and they are not, that is a huge problem. And hopefully this case can stand for notice of their responsibility in complying with the state regulations. What else do we need to address for today? We will have a continued hearing and on all the various issues that you will put before this court. And I know there are many witnesses here who have traveled. And for further hearings, I will allow testimony on Zoom, so you don't have to travel. Is there anything else that we need to make a record of?
Yes, you asked also that the outcome of the federal court hearing, any decision issued by Judge Lawson be provided to the court and all parties, which mostly just you because of the assistants, one of the assistant attorney generals is the counsel on the case, but we would provide you with that as well.
All right, and then I don't know what he's going to decide or not decide, but
Correct.
Then we could perhaps have a status conference, whether it's in my chambers or on Zoom or telephone. Maybe we can have a status conference based on what he does or does not do to see where that lands this case and what it affects or doesn't affect. Is that acceptable?
Yes, Your Honor.
Anything else we need to make a record of?
No, ma'am, thank you.
Just whether my motion was granted, you didn't formally grant my motion for the third party leave on that.
Yes, oh yes, I'm granting you leave to amend for those, 3 local agencies and the former owner. I think that's absolutely necessary. And
I will prepare an order of that effect, Judge.
great. And then what will also happen is there's going to be a number of, there'll be new scheduling order and depositions that will have to be redone or added on to. So work together for those dates. If I need to get involved with that, I certainly am happy to do that, but we need to expedite this case.
Understood, Judge.
Anything else?
No, Your Honor, thank you.
Nothing else, thank you.
I also, and I've said this to you, while there's the 72 hours notice to walk on the property, there is no law that I know of in the above space where a camera can't be sent. So if a camera is sent and I am seeing a violation, that will constitute an emergency motion. This court will hear it at once. And based on what I see and the testimony I hear in regard to that, that may shut down operations. So everybody has a lot to lose if things are not done properly. Have I been clear?
You have, Judge.
Yes, Your Honor, thank you.
Thank you. That is all for today's record. I look forward to our next meeting.